We're going to call to order this March the 19th, 2015 meeting of the Tennessee Alarm Systems Contractors Board. We want to welcome everybody that's here. And Ms. Vess, will you please call the roll?
Thank you. Scott Cockroft.
Here.
Keith Harvey. Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts.
Here.
Let the record show that Keith Harvey is not present, but you do have a quorum, Madam Chair.
Okay, thank you. Next on our agenda is to adopt the agenda, to review and adopt it for today's meeting. Do we have a motion on that?
Make a motion we adopt the agenda as it's presented.
I'll second.
Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to adopt our agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next is the review and approval of the minutes from the December the 11th, 2014 board meeting. Do we have a motion on that, or were there issues with those minutes?
I'd make a motion to approve.
Okay, we have a motion. Do we have a second?
I'll second.
We have a motion, Mr. Cockcroft, and a second by Ms. Jones to approve the minutes. All in favor, voice by saying aye. Aye. All opposed? The minutes are approved. The next item is the election of officers for the board.
Thank you. We do have a board member missing, so I'm going to ask you if you want to try to do his election today. If he comes in, we can do it whenever he comes in, or do we want to try to postpone it till we have a full board?
And we table it on the agenda in case Mr. Harvey shows up, and then agree that if he to postpone it to the next meeting.
Fine with me, if that's what the board wishes.
Do we need a
I
motion?
don't think do we need a motion for that? I wouldn't think.
You could do it by motion, but I think informally you could probably do it as well.
Record, if that's all right with you, Madam Chair.
Okay. Next, the adoption of the Roberts Rules of Order.
Yes, we do need to go ahead and adopt Robert's Rules of Orders with the one exception that the chair can vote. So we will need a motion on that, please.
Madam Chairman, I make a motion that we adopt the latest edition of Robert's Rules of Order, which does, in the instance of small boards, allow the president to participate in discussion and vote.
Okay, we have a motion by Mr. Roberts. Do we have a second for the adoption of the Roberts Rules of Order with the exception on the chairperson voting?
There's no exception required there, Madam Chairman.
With the new rule, with the latest edition. Do we have a second?
And that's basically what we've been operating under. Okay. I'll second.
We have a motion and a second for the adoption of the Roberts Rules of Orders. All in favor, voice by saying aye.
Aye.
All opposed? The rules are adopted.
Next thing on the agenda, I believe, Madam Chair, is a legal report. I have the paralegals went to get another attorney. She's the first one that's on the list. Let me just take a moment to say that I have not been in the office. I have been out for recertification through the TBI, and Beth has had to handle everything that's prepared today, which she normally has everything ready and prepared. But I did want to give her kudos on that, for keeping everything. Have your new staff members, where Rhonda Brown's not new, but Cindy is. What's her last name?
O'Brien.
Oh, Cindy O'Brien. I'm sorry. I get her.
Cindy
I got five
O'Brien.
new ones, so this is Cindy and Rhonda. Right there.
And they are doing a fantastic job processing your alarm employee applications.
Good, thank you.
They've both been working really hard to get the backlog of criminal histories organized and reviewed. I think, based on what Cindy and I did yesterday, the only things left pending review are either approvable or need to be denied material misstatement or app closed because they didn't send any court records. We've had a huge backlog for about a year. So you're looking at some this afternoon that were from like November of last year, and then some that came in January and February of this year.
Thank you.
Okay. Our attorney was Ed Scudder, who is no longer with us. So Tony's going to be filling in for us. Anthony Glandorf. Did I pronounce that properly?
You did, yeah.
Thank you. Wanted to make sure. Robin Ryan will be down shortly. She's the first thing that you see on your legal report about a one we want to represent, but I'll turn this over to our attorney for the legal report.
That makes sense.
Perfect timing. Let me remind the board again, please vote. It's either yay or nay, and every vote is important. We need to see audio that you are and hear audio visual, please.
Election I didn't know about, please vote, so. Good morning. My name is Robin Ryan. I'm one of the litigation attorneys for the state in the regulatory board matter. What you have before you today is a case that was put into litigation monitoring. Litigation monitoring happens when we have a case that's in court that has, based on similar facts that have been alleged in the complaint, and we put in litigation monitoring for a number of reasons. Number one, it's free discovery for us, because often what happens in court, we get facts that we can't get easily here. Number two, facts come out that may absolutely impact what we do here. May turns out we have a worse case, may turns out we have no case at all. So typically what we do in basically all the boards when something's in court, we ask the boards and commissions to allow us to put litigation monitoring. The respondents then sign a litigation monitoring order, which basically says, you're in litigation monitoring, but you have to report to us, you have to get us the information, if there's any discovery you get, we want it, et cetera, and they comply. That is what happened in this particular case. This was originally presented in 2012. Respondent 1 was the company, and Respondent 2 the qualifying agent. And you can probably read this, but let me sort of explain it. This was involved with a company that another company brought a lot of the allegations as well. There were some of the members, some of the employees were representing themselves as a member of the company that's complaining and sold them contracts that was in really bad business practices. Well, let me tell you what happened. They sued. The other company sued. They won. Well, they won because they reached a settlement agreement. As part of that settlement agreement, the company that was against the alarm company that we're talking about, the company that sued them got a $2 million settlement. They signed a litigation, a settlement agreement that says their employees absolutely, number one, cannot represent themselves in any false or misleading way, which is one of the issues we had here, have to all be licensed and registered before they go out. Everybody has to be. That was also one of the questions we had. And the injunctions are permanent, and it includes all present employees and future employees. Exactly the kind of thing we were looking at when we presented this matter. And because of that, I'm asking that because of those issues have been resolved and because they paid a hefty fine for what they did and they've got the things in place, I'm asking that we go ahead and dismiss this one due to the actions of what happened in the court. Question or two?
It's on your iPad.
The last things you should know is part of the litigation issue. We also have problems. This is an older case. The complainant that we had was the first complainant. She's very elderly and ill, not likely to be able to come to testify. I will tell you that the former qualifying agent, he's not going to come and testify. So if we go forward with litigation, we're going to have a difficult time as well. But more importantly, I want you to focus on the results of what happened in court and why I think that what our issues are here. I am. Miss Cody.
I can't get this thing to work.
Oh, you can't get,
Well, we'll get you another one.
would you help? Mr. Ryan?
It's probably ignorance on my
I
part.
doubt it. Sometimes they don't load, so.
We do have it on the screen, though, if you.
And hard to scroll on the screen, though.
Oh.
Now, how did you get there?
And there's this other one up here.
Ignorance on my
Yeah, there's
part.
one right there,
I'm
Keith, for Keith.
not blaming
too.
a mechanical failure here.
That's the one without the cover. It probably didn't load. Well, it might
I
have.
think it's loaded. I just couldn't get it to function.
It's open now. I'm just trying to find the one it's on. It's number Exhibit
Hey.
A. There you go. Same place.
I think the only question that I have is, with the proof that was presented in the federal case that awarded the judgment, that couldn't be pulled, or the agreement.
And
Okay.
that's the difference.
But the state can't use the proof that was presented there to,
Well, we could, but I can't use it as the only proof, no, because it's not exactly the same. It's not exactly the same as here. It just involves the same people and similar, and it wasn't presented exactly the same way. So I could, yes. But remember, I still have to have the people that brought these complaints to testify. It would be a portion of it. And just one other thing to recognize, our purpose here is to rule and govern and make sure the company. And essentially, that's exactly what it resulted as a part of this federal lawsuit. Frankly, it saved us a bunch of money and time getting the results we were seeking in the first place.
The one thing that, the amount of the settlement was so large, it makes me wonder what was
Well, there was-
going on there.
Well-
If they forfeited contracts, or did they really pay anything? Were they,
They paid the settlement.
okay.
Yeah, they did pay the settlement. This was a bigger issue with other things going on with this particular company. Other parts of state, not necessarily ours, were involved. It was a border state. And the issues were basically some of the exact same. These employees were going to the houses, sort of alluding they were brought by the other company. Frankly, I'm not sure the employer absolutely knew about it, and that's something we'd have to prove as well, because none of these employees that I'm talking about, the ones that are there, they're not going to testify. The ones that may not be there, we'd have to get them in somehow to testify. I actually think, as I said, the injunctions in the settlement offer are very large, and they are absolute, and they absolutely do exactly what we were intending our license and registration people to do in the first place. And if we go forward, this is just my opinion, mind you, and I'm just giving you my opinion, we're basically charging them again for something that was resolved anyway. And they are not just under the law now, they are under a settlement agreement that if they do not follow that settlement agreement, it is brought back to federal court and could result in much bigger fines and penalties.
I know in the past that the board has taken the position that our intent is to bring people into compliance rather than try and penalize them after they haven't been. And it would appear, based on what you've explained to us, that this settlement, the federal settlement, would do that in a good fashion. So I personally would be of the opinion that we could drop this and still feel like the board has fulfilled its responsibility to the general public. If you would like, I'll make a motion to that effect.
I just want to point out one more thing to help you with this. If you notice, the date on this is 2012, and you notice that since then we don't have these complaints. It's not a continuing action of this particular company. is
They
it?
are licensed and all at this point, because it shows expirations in the future, so.
Madam Chairman, I make a motion then that, based on the advice of counsel and the information presented, that we drop this particular complaint.
A second.
We have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this matter to dismiss this complaint. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Thank you.
Very much. Hope to see you again at a hearing, maybe sometime. Thank you.
Thank you.
Great, good morning. I saw you all several months ago, probably, when I was introducing Ed Scudder to you all as your new board attorney, because we promoted Josh into his position with the Contractors Board. Josh is doing very well, by the way. He's excelling in there, and he's getting to work a lot of interesting issues with the legislature and with the professional associations of that board, which is very good work to do, because it shows that he's very much matured as an attorney, and we are very proud of him and the work that he's done. So that's your update on Josh. I would also apologize that I would assign an attorney to you who would leave several months later, but that's not something that Ed did wrong or that we feel that he did wrong, but he took a new opportunity at TennCare last month, and he said that was a good move for him, and he was excited about that. Ed had worked with our department for a very long time, and I asked him, I said, you have to call me back and tell me how many times you got off on the wrong exit to come to this building, as opposed to drive over to Metro Center, which is a little bit down the street, or even possibly came to the parking lot and then realized that you're not at the right workplace. So my understanding is that he is doing well, and we are in the process of getting a new attorney for you all assigned. We've had all the paperwork that I know of that's been approved, so we're just in the area of trying to do the interviews and actually finding that person. I assume they'll come from outside, and oftentimes we get applicants who have some background with administrative law and these types of boards and regulations, and sometimes we don't. So it's a very specialized niche, and not many of us have actually done it before once we come on board the learning process. So my pledge to you is I will train and teach that person the best that I can so that they can be the best attorney for your board, and we'll make them really good, and then we'll probably put them somewhere else when Cody really starts to like them. So.
Yeah, we don't have a really good track record with attorneys, and I was wondering if Mr. Scudder had the shortest run with us out of the ones that we have. I just knew his was very short, so.
We've had some excellent ones too.
Yeah, we have.
Right. Well, that's our goal, because we want to be efficient and we want to give you the best and most competent legal advice that we can. So at the end of the day, hopefully you may say that you like us, but hopefully that you say that you like the work that we do for you and the advice that we give you. So today you all have me. I decided not to give you all an interim attorney for a couple months and try to throw somebody into the fire and do that, because it creates more headaches and hassles. So I'm going to be presenting to you the legal report, all other legal matters for today, and potentially the next meeting, depending on how that happens. And I have to say that it's been interesting going through all of this, getting reacquainted with the alarm board laws and rules. And I have to say that I really appreciate Regina Oldham, who's sitting behind me, who's the paralegal for this program, 3 other programs, and then 4 other programs on that. So I believe 8 or 9 programs that provides the paralegal support for, and she's done a great job, because without a full-time attorney on the program, we really do rely on the paralegal to get a lot of this done, because my time has to be spent elsewhere. Sometimes I'm just kind of run thin. So with that, I'll finish the introductions and we'll get down to it. My understanding is that your attorney generally reads the legal report to you all. I will do that. If you have any questions, please stop me. If you have the recommendations here are a combination of trying to retain the institutional knowledge as to what the board generally likes to do. And so if we have missed something or if you have questions about that, please do not hesitate to stop. I'm sure you won't. And I have no hard feelings about making changes to any of this because it'll be a learning experience so far as we get down to the recommendations for civil penalties. And I have the cases here next to me, so if you have questions about a specific case, hopefully I've reviewed them all, so hopefully I can answer that off the top of my head, but I should be able to reach into the file and just turn a few pages. So the first case is case number 201402561. Here the complainant alleges that the respondent who is a registered employee engaged in unlicensed activity as alarm systems contractor in violation of Tennessee Code 6232-304 and engaged in misconduct in violation of 6232-319. The complaint alleges that respondent was terminated by his staff employer effective October 2nd, 2014, and his termination was processed by board staff. On October 13th, 2014, respondent's employer rescinded respondent's termination and was told a transfer application would need to be completed. On August 2nd, 2014, now we're going back into the past beyond this, the respondent asked the customer to prepay for 2 years for a service of $600 and collected his commission of $200 before the prepayment had not yet been paid. On October 1st, 2014, the respondent made a customer that was the same customer write a check for personal funds of $600 in his name for work contracted by his employer. The respondent purchased equipment for the customer in cash, not using the company account. The respondent claims he was trying to save the customer from paying for a service call. The respondent's employer withheld the $600 from his paycheck. These actions were reported to the board staff by the employer. The employer states that they have counseled with the respondent and he understands the seriousness of his actions. Respondent has previous complaint for working without registration. Our recommendation is authorize a formal hearing and a consent order to settle the matter with a civil penalty in the amount of $1,000 for violations of 6332-319. Oh, no, it's supposed to be 307, I believe. 307. Typo. Okay, make that change. Now the and the $1,000 was for. The rest of the story that was in there is that the owner of the company said, "I would like to rehire this person and give them a second chance," and we have counseled him. The QA says, "I completely disagree with that, but that's what my boss's wishes are. I wish I didn't have to work with this guy. I think he's unethical, and I really don't think that he's sorry for what he did, and he'd probably do it again. But my boss has required me to tell you all that we're rehiring him." So with that information from the QA, that's why the authorization for the civil penalty for misconduct. Case number 2014002. Sorry. Oh, I'm sorry. Do you all vote every time? I apologize.
Yes.
I apologize.
It's
Sorry.
okay.
Complainant is the alarm contractor and the respondent is the employee, and they're now wanting to rehire the employee? Or they have
They are. The complaint first came in, I believe, from the QA saying that I terminated him. And then I think after they got to the facts of it, after he investigated, his employer, the owner of the company, said, "No, we're not terminating him. But we're going to keep him. Rewrite a letter." That's hearsay as to how that happened, but I can see the series of letters saying I've been required to tell you that we're rehiring this person. The customer had prepaid for their services out to 2014, and back in September, and he still had a payment left for the end of the services at that 2014. So back in September, this respondent got them to make that final payment in September of $600. And then he said, "Well, how about you sign up for another 2 years?" Okay, even though it's not expired, it was at the end of 2014, had yet to expire. So he got him for another two years, and then the payment was supposed to be due at the termination of that then at 2016. So he called him up. This is what we have in the file. Called him up roughly in October and said, "Will you go ahead and make that final payment of that other $600? And he convinced him and said yes. So that's where he put it in his pocket, and he went out and purchased the equipment on his own. And then he tried to get it installed, and it didn't work. So he asked the installer for the company, "Can you come out and install this and not tell our boss about it?" And so that's when the boss found out and said, "You need to come back to the office. We need to talk about this."
So this is it's for unlicensed activity, basically, on on his part.
Yeah, well, the unlicensed activity was part of it in that he was attempting to, buy this for his personal funds and install this and do it all himself.
Trying to operate as a alarm contractor.
Right, he would have been acting his own company, but it also falls under the misconduct wherein you're attempting to get somebody to write you a personal check, for the services that are being provided by your employer.
I'm not sure I understand the $600. The respondent asked the customer to prepay for $600. Who got the $600? So the employee took the $600.
To try to go purchase it on his own and put it
Okay.
in and reap the
Kept his
reward.
commission.
Trying to
That wasn't
operate.
clear from clear to me from
Right.
the text here. Maybe it was just I wasn't reading it properly.
And then there's a separate allegation that after he was told to come back to the office and talk to his boss, the QA alleged that he called the customer on the way back to the office and said, "Would you do me a favor and lie for me about what I actually just did?" And so the QA talked to his customer and said, "I apologize for the way that this has happened, but we're going to take care of it." So all of the $600 was shored up for under the was accounted for at the end of the day.
Just $1,000 in line with our guidelines.
Yes, for unlicensed activity.
Madam Chairman, I make a motion that we authorize a formal hearing and send a consent order with a civil penalty in the amount of $1,000 based on misconduct and Tennessee Code annotated 6332-319. Excuse me, 62 is a misprint here. 6232-319.
Okay, we have a motion by Mr. Roberts to concur with the council's recommendation in this matter. Do we have a second?
I'll second.
And we have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 2, case number 2014027591 and 2. Here, this complaint alleges that the respondent, Alarm Company, failed to notify the board of the qualifying agent leaving the company within 10 days. Additionally, the complaint alleges that the QA, who is respondent to, failed to notify the board of his termination of employment. Notifications are required under Tennessee Code 6232-304 and the board's rules 90-01-.069K and -01-.078. The termination was on July 31st, 2014. Notice was received on September 3rd, 2014. Our recommendation is authorize a formal hearing and settlement by consent order to respondent 1, who is the company, with civil penalty in the amount of $250 for the violations, and authorize formal hearing against respondent 2, who is the DQA, for civil penalty in the amount of $50.
Madam Chairman, I make a motion that we concur with the recommendation of council.
Okay, we have a motion by Mr. Roberts to concur with our council's recommendation. Do we have a second?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 3.
Case number 201402 8291. Here, the complainant alleges that the respondent alarm company failed to display its alarm certification on an advertisement dated October 26, 2014, and distributed on October 28, 2014 in violation of Tennessee Code 6230. The respondent states that they applied for their license and it was approved in September 24, 2014, but the advertisement was inadvertently released through a scheduling and coordination error. They state that they have put policies in place to avoid this from happening in future. A previous complaint under case number 2014027671 was considered by the board regarding the same advertisement in its December meeting and was closed. As of February 15, 2015, the respondent still has failed to correct their advertisement by adding their certification number. Therefore, we recommend authorization for a formal hearing and settlement by consent order to the respondent for civil penalty in the amount of $250 for violations of 6232-316D.
What was the reason why we closed the December one, do you know?
The way it was in the minutes, it said that the recommendation was that since the license was issued, whatever date it was, this flyer went out either shortly before or shortly after that.
Had to do with their licensing at that point. They were not licensed when, this is different. This is about having the license number on it,
All their advertisements, yes.
which if they weren't licensed, if they didn't have their license yet, they wouldn't have known their number.
They were, again, the first complaint was closed. It wasn't
Right.
dismissed, it was closed.
And you would think at this time that they've had adequate time to,
Correct their
This is the
errors.
same date, or are these the same dates or the same, they've distributed the same thing again since then?
I have,
This is
They've
different from the
never
first
put their
complaint.
certification number on anything. It's almost a continuing.
right, so what I have in front of me is this is an advertisement with the company's name on it now. I won't tell you what it is. It's printed off the internet. It's from their website. It was printed off March 10th, 2015, so this was just last week. And on the very bottom of their website, we have gone down to where they list all of their license numbers in very, very small print. I have one from Arizona, California, Florida, Georgia, Illinois, Indiana, Kentucky, Minnesota, New Jersey, New York, Pennsylvania, South Carolina, Texas, Virginia, Washington, West Virginia, no Tennessee.
being on the internet would be
And-
something they could change quickly. It wouldn't be
Right.
like a yellow page ad or something.
And
that
we
would be
have
very
a-
difficult to change.
Right, and we have a letter from, they had responded in December 2014, I assume this was on the previous complaint, that says, here I am, the controller for, the compliance manager wrote us a letter saying he apologizes very much, and beginning January 1, 2015, our company's advertising in Tennessee will be placed with our certification number on it. So this is 3 months later, and it hasn't happened.
Madam Chairman, I make a motion we concur with the recommendation of our council.
I second.
We have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 4, case number 20140288311. Here the complaint alleges that the respondent QA failed to notify the board of his termination of employment with an alarm company within 10 days as required by Tennessee Code 6232-304 and Rule 90-01-.069K and -01-.078. A termination date was on July 11, 2014. The notice was received on October 20th, 2014. Our recommendation was authorization for a formal hearing and to send out a consent order in the amount of $50 for this violation.
Their first violation of this type.
I make a motion, we concur with council.
Second.
We have a motion by Ms. Jones, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 5, case number 2014024301. Here, a complaint was established against Respondent Alarm Company when the board office received a termination transfer form for an employee who had never been registered with the board. The employee's employment date was listed as March 18th, 2013, and termination date was listed as August 13th, 2014. The complaint alleges failure to register an alarm employee. This case was originally presented to the board, and you all had asked for additional information regarding the job duties. We received information back from them, which states that this person was first employed March 18, 2013 to January 19, 2014, who worked in as a control center specialist, was an alarm operator, and then that from January 2014 to July 2014, they were in a leadership development position, which trains employees to generally so that they are offered management type positions in the future. The employee did not process any alarms at this time. And then on July 15th, they were hired as a position as an outside sales rep. And then less than a month later, the employee was terminated. Our recommendation here that we have was to close that the training time discounted. They worked for less than a month. There is some contention potentially over the original, the first. I guess I recognize that the first job that they had under the control center specialist, they did admit that they found that they had like limited at one point in time access to some information, but it wasn't like over a period of time. It was like for this instance and then that instance. So without any more information, it almost appeared to be de minimis, that wasn't really what they were supposed to be doing. So that's why the recommendation was to close.
They worked for 10 months as a central station operator?
Yes, they did. Yes, they did. And so I have a limited understanding as to exactly what that is, but I can tell you what
Registered position.
it is completely.
Yeah,
Okay.
I can't agree with the
Okay.
recommendation
Well, I completely
here.
understand that.
And I think that was our concern. We wanted, because it sounded like they were trying to say the person was entirely in training for that period of time, but clearly they've said they for 10 months, I think roughly. And I think we should have something based on that.
Okay. Then I would not mind changing our recommendation based on what you all have told me here too. I believe the first instance violation, I believe, is it $50 for failure to register the employee?
$50 a month
Per month. So we're looking at
for first offense.
March to January.
Well, I would think that the employee, since the employee should have been registered in back in 2013, March of 2013, that the entire time should be applied rather than just when the person acted as an operator. So that would be 18 months?
The original was 16 months that we brought
16
you last
months.
time.
August of 14 was a year.
I would think that a penalty, an offered penalty in terms of the 16 months times $50 would be appropriate.
There was some information regarding, they indicated that during the training period that they did not have any access to any records or actually do any kind of installs or anything of that nature. So there was some contentious on their side regarding that training period. So I think there's probably the more gray area, but I think we can recommend as the board wills on that.
If a person
time
should have
period.
been registered initially,
Yes.
then the fact that they were then moved into a training program, I would not think of any consequence because they wouldn't have canceled their registration during that period of time.
Well, that's true. They would not have. They would not have.
I think a happy medium would be to do the 10 months, but because they weren't in an unlicensed position at that time. But
I think that the penalty should be looked at for the entire period that the employee was part of the company.
Is that your motion?
Yeah, I'll put that in the form of a motion. Madam Chairman, I move that we authorize a formal hearing and that we offer a civil penalty of $50 per month times the, 16 months? 16 months that the employee was employed, and I don't recall the exact paragraph and certification number that probably should be cited there, but I'm sure council can add that.
And I'll second.
312C, I think.
6232, 312C. Okay. We have a motion by Mr. Roberts, a second by Ms. Jones to authorize a formal hearing and a civil penalty of $50 times the 16 months that this employee was employed but not registered with this company, all in violation of 6232, 312C. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Who made the second?
Ms. Jones.
Number 6, case number 201403008 and 2. Here the complaint alleges that Respondent 2, which is a security company unlicensed in Tennessee, sent emails to residents advertising security systems in violation of 6232-304A. On Respondent 2's website, they reference Respondent 1, which is, it says here, a security company that's licensed in Tennessee. They're alarm company licensed in Tennessee. And listed Respondent 1's license number as their Tennessee license number. Respondent 1 participated in a joint venture with an unlicensed company, which was Respondent 2, in violation of 6232-304E. Both respondents apologized to the board and stated that they had employed an outside consulting firm to advise them on this, and they were advised that Respondent 2 did not have to be licensed in Tennessee. Recommendation is authorization for a formal hearing and a consent order for settlement to Respondent 1 for $500 for engaging in a joint venture with an unlicensed entity, and authorization of a formal hearing with a consent order to settle to Respondent 2, also for $500 for engaging in a business of alarm systems contract without a certification.
Chairman, I make a motion that we concur with the recommendation of council.
We have a motion by Mr. Roberts to concur with their council's recommendation. Do we have a second?
Second.
We have a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Number 7, case number 201403018. Here the complaint alleges that the respondent security company failed to register 7 employees within the 30 days of their employment as required by Tennessee Code annotated 6232-312D. All applications and transfers were received on October 31st, 2014, all at the same time. This is a breakdown. License number 32383 had a hiring date of August 8, 2013. It says here 3 months. And I'm looking at my timeline here and I'm thinking, I think that's supposed to be 3 months, 12 months plus the 3 months, and I apologize for that. So that should be. I'll look at my paper real quick to make sure that that date is supposed to be a 3 or a 4. It is 2013, so I would like to amend that to make it 15 months, and I'll do some math here in a minute. License number 32381, January 28, 2012. That's 21 months. License 32384, hiring date January 1, 2014. That's 10 months. License 32385, hiring date July 8, 2012. That's 27 months. License 32382, hiring date 10/1/2013, 12 months. 32380, license number hired May 19, 2014. That's 5 months. And license number 2953, hiring date June 3rd, 2014. That would have been 4 months.
Your math is correct, I believe. I think it
Oh,
was.
was it
just
down there at the end?
I just
Oh,
think
that's-
there was a mistake.
It was probably
in
just
the
misstated there. I'll
date.
make sure. I apologize for that. So based on that, we recommended, based on your schedule of civil penalties, authorizations for a consent order to respondent with civil penalty in amount of $4,100 for violations of 6232-312D. That's $50 times the 82 months of the unemployment time total.
With counsel for just a second, please.
Sure.
What we're saying is,
If we could, I'd like to
I want to take
skip this one, table this one till the end, because there's a little bit of, there may be an issue regarding the date that this company was actually licensed as an alarm company when they started doing business, that they may have been in existence doing something else at that time. So what I want to do is make sure that we are actually, that the months that we calculate here are the months that they have when they were actually an alarm company, when they did not register employees and not when they were doing some other work that was not required to be licensed. So if we could table number 7 and bring it to the end, that'll give us some time to work out that math.
So move on to number 8.
Yes.
I want to just take a moment here and explain. Ed Scudder did this legal report before he left. So Tony, myself, and Beth were all been extremely busy, and I do apologize. So that's why every effort to make sure these are correct. So this is why we're having some discussion. So just bear with us if you would, please. Thank you.
Okay, thank you.
Okay. Well, number 8, 2014030601. Here the complaint alleges that the respondent security company failed to register an employee within 30 days of employment as required by Tennessee Code Annotated 6232312D. Employee worked from January 2014 to June 2014. As such, we recommend authorization for a formal hearing and a Senate consent order for settlement to the respondent with civil penalties in amount of $300 for violations of 6232312D for $50 a month times 6 months.
Math correct on that.
You include January.
February, March, April, May, June.
Look at the date in January to see exactly.
This weekend of January.
It may be. I'm just asking, is it correct so it doesn't come back? Well, they have to stay until February the 14th to have been there 1 month. That's what I'm saying. If they started on January the 14th, if,
Start on January 2nd.
30 days, I'm just questioning it to make sure it's correct.
5 months and not 6 months.
Mine just says January to June, and if I do February, March, April, May, June, that's 5.
Madam Chairman, I make a motion that we concur with the recommendation of council with the exception of make the amount $250, which would cover 5 months for $50 per month.
Do we have a second?
I'll second.
We have a motion and a
A
second.
second.
Uh-huh.
It didn't work the first
Okay.
time.
We have a motion by Mr. Roberts, a second by Ms. Jones to concur with council's recommendation, but to reduce the civil penalty to $250 instead of $300. All in favor voice by saying aye.
Aye.
Aye. All opposed? The motion carries. Case number 9.
Number 9, case number 2014030971 and 2. Here the complaint alleges that a respondent, a qualifying agent, he is respondent 1, an alarm security company, respondent number 2, engaged in the business of an alarm systems contractor without first being certified and without a qualifying agent in violation of Tennessee Code Annotated 6232304A and B. The board staff initially received a Better Business Bureau application that indicated the respondent had started locally with his business in August 2011. In the response, the respondent states that he meant that he had worked as an installer for a previous company since 2011. He filed for a certification on the same month for the application with the Better Business Bureau. Before I get to the recommendation, I'll give you some more facts because it's very detailed and I wanted to give you the gist of it there. partially telling the truth. Yes, since 2011, he was a registered employee for an alarm installation company. However, what we have, and he filed with the Better Business Bureau because he was starting up his own company and getting registration with us. But what we have here is actual printouts from the internet from November 2011, and it's an alarm company, which is, say the respondent's last name is Mr. Jones. This is called the Jones Alarm Company. Is an expert in helping you find what you need perfectly for your home and business, giving you the right technology. Our technicians will leave you with the best security technology and understanding, whatnot. So from what we have here is that he was registered as an employee at a company previous to him filing with the Better Business Bureau. However, it appears that on the side he has been advertising his own alarm company for several years, and that alarm company in itself would have been operating unlicensed and without a QA. It appears now that he has come to create his own alarm company, but we're really only getting half the story. So based on what we have, our recommendation is an authorization for a formal hearing and a consent order to respondent, one with a civil penalty in the amount of $1,000 for violations of 6232-304A. And I would like to add that we do a recommendation for a violation against respondent 2, which is the alarm company, in the same amount for $1,000 for unlicensed activity as an alarm company.
So there would actually be civil penalty proposed against the 2 respondents then?
Yes.
I was kind of curious about that.
It was my initial thoughts was to do $1,000 apiece, giving the egregiousness of the action, meaning that we were actually lied to in our response here. As to the actual facts of this, when we had it clearly printed off from the internet, he would have knowingly evading the law here.
So your amendment is actually for $1,000 against the company for unlicensed activity and for the person, the individual, correct?
Yes.
Okay.
Madam Chairman, I make a motion to concur with the, maybe I should say revised recommendation of council, but which would involve the proposal of a civil penalty of $1,000 each against the qualified applicant respondent 1, and also the alarm company applicant respondent number 2.
Do those entities, I mean, when they were in violation, they really weren't 2 separate entities, were they? I'm not necessarily opposed to it being more than $1,000, but the concern is that you're trying to go after, I mean, it really was one, there weren't 2 entities that were unlicensed. It's like
Well, it's not really 2 entities, but it's 2. You've got the applicant and you've got the company. So.
Well, I would say this is that sometimes it's semantics, but and I understand what you're saying, but in this scenario, the document that I have in front of me shows that the company that he had is actually a company, actually a legal entity, which in itself it's not a sole proprietorship, so it wouldn't be him himself and then him himself. It's him himself and then his actual legal company.
I think I'd also point out, as council did, that would appear to be particularly egregious behavior.
I second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's amended recommendation in this matter. All in favor, voice by saying aye.
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 All opposed? The motion carries. Number 10.
Number 10, case number 20140311791. Here the complaint alleges the respondent, by and through his qualifying agent, failed to register 2 employees within 30 days of their employment date as required by Tennessee Code 6232312D. The applications for these employees received by the board on October 23rd, 2014. Their license numbers were 32344. The employment date was May 17th, 2014. And license 32345, employment date May 13th, 2013. In his response, the respondent states that the dates listed on the respective applications was not the date of the hire by the respondent. He emphatically states that his employees did not start working in the state of Tennessee before they received the registration cards on November 5th and November 6th, 2014. We don't have anything in the file otherwise that would dispute this, and as such, we recommend authorization for a letter of warning to the respondent.
This a out-of-state company that where their employees would be doing something outside the state of Tennessee, perhaps?
I believe so. I believe this was in the state of Georgia. Was it in-state?
But they just opened a new.
So the allegation that the employee or the employer employees in question were in fact employees of the company elsewhere, and okay. So that would add some credence to what they're alleging there.
Sprinklers and suppression and that
Okay.
type of thing.
Thank you. Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
We have a motion, Mr. Roberts, a second, Mr. Cockcroft, to concur with our council's recommendation in this. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Number 11, case number 2014031801. Here the complaint alleges that the respondent, by and through his qualifying agent, failed to register an employee within 30 days of his employment date as required by Tennessee Code 6232-312D. The employee began to work on June 16, 2014, and the application for the employee was received by board staff on September 24, 2014. In its response, the respondent states that the employee went through 45 days of in-house training and did not have access to confidential information before he received his registration. Additionally, he states there was a delay in processing their application because of obtaining certified court documents. We don't really have anything to dispute the 45 days in-house that we had there. As such, we recommend an authorization for a letter of warning.
This is a monitoring company of some sort?
No, it's an out-of-state company.
Out-of-state company? What this particular employee does? If it's an in-state company, a 45-day period of training without doing anything just lacks credence, in my opinion. If it's an out-of-state company where the employees could have been involved in training and some other, in some other things that don't require licensing, then their allegation makes sense.
They are an out-of-state company, and their letter says that this person was hired as a service technician. His job includes servicing equipment purchased by customers, performing preventative maintenance on equipment. And he said his business practices is that the field service employees may not service or have access to records, diagrams, or any of those natures until they have received their state alarm license. He went through 45 days of training, in-house training. There was then a delay submitting his request.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
We have a motion by Mr. Roberts, a second by Ms. Jones, to concur with our council's recommendation on this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Well, number 12, case number 2014031831. Here the complaint alleges the respondent, by and through his qualifying agent, failed to register an employee within 30 days of his employment date as required by Tennessee Code 6232-312D. The employee began to work on March 19, 2014, and their application for the employee was received by board staff on September 18, 2014. This is respondent's second complaint of this type. In the file, I'll give you more information. In the file, they did admit to this violation. Our recommendation is authorization for a formal hearing and to settle by consent order with a civil penalty in amount of $600, which represents 6 months times $100 per month for second offense.
I make a motion to concur with council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second?
Second.
Second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All
But
opposed.
who made that motion?
Ms. Jones and Mr. Cockcroft, second.
Sorry, we were consulting again.
Okay.
All right.
Number 13, case number 201403 1841. The complaint alleges that the respondent by and through his qualifying agent failed to register 2 employees within 30 days of their employment date as required by Tennessee Code Annotated 6232-312D. The applications for the employees were received by board staff on November 7, 2014. The employment dates for these 2 persons were May 5th, 2010 and January 2nd, 2017. In response, the respondent states that they're located in the state of Georgia, that the employees have been with their company since its inception, that the dates listed on the respective applications was the date of hire by the respondent. Respondent states that the company did not work in the state of Tennessee before December 2014. We have no proof otherwise in our file to dispute this. Therefore, our recommendation is to close the complaint.
This is the same thing as the other one.
Madam Chairman, I make a motion we concur with the recommendation of council and close this issue.
Second.
We have a motion and a second, but do we need some more information from staff?
Apologize. We were just conferring that this one is similar to the last complaint, wherein that this company was not not necessarily licensed back in 2010. So the date on 2010 really is not germane. It actually encompasses more times, but that does not actually change the underlying fact that they weren't actually doing business in the state of Tennessee during that period. Apologize for the confusion.
Okay. We have a motion by Mr. Roberts, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed.
Number 14, case number 2014031981. The complaint alleges that the respondent by and through its qualifying agent failed to register an employee within 30 days of his employment date as required by Tennessee Code Annotated 6232-312D. The employee began to work on July 1, 2011, and the application for the employee was received by board staff on November 17, 2014. In its response, the respondent states that the employee did begin work for them in 2011, but had not received any sensitive alarm information, did not perform any work on fire alarm related equipment. The respondent states that they did not receive authorization from their corporate office to begin operation as a fire alarm division until January 1, 2015. We have no other proof or admission otherwise in the file regarding this, so we recommend to close this complaint.
Would
I see, go ahead, Ken.
Go ahead.
No, I'm wondering about the dates. It appears from 2008 until 2014.
One of these large companies
This
that
company
has
wasn't-
several divisions. They didn't open this office until, I don't think they got their license until
Indicate the
they reapplied for that office, and it was approved in August of 2014. Again, they do a lot of different things, so.
They don't do anything other than fire that's regulated by this board, or?
Our alarms, they do a lot of other things that we don't regulate to deal with fire alarms. It's our other stuff.
Madam Chairman, I make a motion that we send this company either a letter of information or a letter of warning, not to particularly penalize them, but just to make sure that they fully understand the requirements for that. So I think a letter would be more appropriate than just closing it anonymously here.
Okay, we have a motion by Mr. Roberts to send the company a letter of warning. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 15, case number 2014031911. Here the complaint alleges that the respondent by and through his qualifying agent failed to register an employee within 30 days of his employment date as required by Tennessee Code Annotated 6232-312D. The employee had begun working in October 14, 2013, and the application for the employee received by the board staff on November 14, 2014. The respondent did not respond. Well, sorry, I would like to delete the last sentence that says the respondent did not respond from the board's to the board's complaint because I received information this morning that they in fact did. So I would like to amend that sentence. So therefore, our recommendation is authorization for a formal hearing and send a consent order to the respondent for a civil penalty in amount of $650 for violations of 6232-312D, which was $50 times 13 months. And then I would like to delete from my recommendation beyond the word plus.
Just for failure to register, not for failure to respond.
Yes.
Okay.
Madam Chairman, I make a motion to concur with the revised recommendation of council that would involve a proposed consent or a consent order or a proposed civil penalty amount of $650.
We have a motion by Mr. Roberts to authorize formal send a consent order in the amount of $650 for violation TCA 6232-312D, which is 15 or 13 months at $50 per month. Do we have a second?
Second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
16, case number 201500328. This complaint alleges unlicensed activity on the part of the respondent. The respondent is located in Texas, but is allegedly monitoring alarms and live video for a car dealership in Memphis. We have in front of us a recommendation for authorization for a civil penalty in an amount of $500 for violations of 6232-304A.
Is this a first offense or is?
How long has this been going on?
Have
You
a-
know, it's expired
Yeah.
13 or so years ago.
Their application expired. They never were licensed.
They were
They have-
never. Sorry.
I'm sorry, they applied for a license and never completed the process, so we closed it.
The license was never issued. We have a complaint. We have a person whose complaint that provides the name of the car dealership that they're doing services at. In the file here, the only concern that I would have, to be quite honest, is that the letter we received from this company says very plainly, very simply, we do not monitor any customers in Tennessee. That's it. What I don't have, what I'm recognizing that I don't have in front of me is, other than this allegation that they monitor this, is an actual proof that they actually are monitoring this. So let me do this. Would it be possible for you all, in order not to lose this complaint bringing back, could I get an authorization that if we can confirm with the auto dealership that this is the person who services their account, that we send a consent order that, as we recommended, for $500, and if they deny that this is their person, then we close the complaint? Or do a letter of warning or something of that nature. Do you all understand the issue that I'm looking at right now?
My concern is that, we've issued consent orders and, for in excess of this to licensed companies. And if you went by every month of every employee and all the other stuff, I mean, this could be way more. It doesn't seem fair to
I
the
see.
licensed companies if they are, in fact, doing business.
Okay. Maybe I could work on that if you all would be in agreement if I amended our recommendation so that if we could find out from the car dealership how many months they have been monitored by this company to authorize a certain civil penalty per month based on the dealership's information. And then if they deny this and say, no, this is not our alarm company, then we just send out either close it or a letter of warning, something of that nature. I'm a little bit perplexed that we would have such detailed information about this people servicing. I have addresses, the actual dealership and all of that. And it looks like what we don't have is actually information, verification of this, right? And I'm looking this and I'm wondering, and I apologize.
You've got
this
detailed
this should have been
allegations,
done.
but you don't have
Right.
verification that
Right.
it's been
And I apologize. That should have been
validated.
looked at beforehand, and that has when I was reviewing these, I did not. I didn't go and look to see if that actual verification was there. So I apologize for that, but I think that this could be a way of actually amending the requirement, the recommendation, so that we would not lose time on this complaint. We can actually do what the board would request.
I would agree with that. I think we need to make sure that we verify, though, as far as that company's not in. So a lot of times they could be doing monitoring and they may think their alarm company is Company A when Company B is actually providing the service, the wholesale standpoint. So we want to make sure that if the answer that you got from them wasn't the local company, doing the service, but this other respondent is really still monitoring wholesale for the car
Yes.
dealership.
Yes.
We have a motion by Mr. Cockcroft to concur with our council's amended recommendation. Do we have a second?
Second.
And a second by Ms. Jones. All in favor, voice by saying aye. Aye.
Madam
All-
Chairman,
yes.
I must
Sorry,
confess,
go ahead.
I'm not real clear on what the motion is, because I don't think our recommendation of council was completely clear. There were some,
If he can verify through the car dealership that the company named in the complaint has actually been providing the monitoring service with unlicensed activity.
I would agree
And
with that portion
to
of it.
determine a period of time that this activity's been taking place, then the penalty will be based on the number of months times the penalty.
We didn't, I think we
But we didn't
really should
establish a
include
penalty.
what the penalty amount would be.
Or do you
in that
want it
sort of-
to-
I think the motion that we've got is really very vague, and, I'm in agreement with the principle, but I'd like to see the rest of the details included in the motion so that we don't have an issue later on.
I could probably help with that. Our amended recommendation would be for authorization for a formal hearing and send out a consent order to the respondent for civil penalty in amount of $500 times the number of months that legal counsel can confirm with the dealership as to the unlicensed activity of this company for violations of 6232-304A. And if legal counsel cannot confirm any unlicensed activity against this company while looking into the actual, not just the company that they have the contract with, but the next company, then we would close this complaint.
Madam Chairman, thank you for the clarification, and I would vote in favor of that motion then.
Okay. So, well, we said council's amended recommendation. I don't know if we need to do a complete revote or not after he's read it.
I think he just clarified the motion that
Clarified
we
the
voted on.
motion. I think we know what we wanted, and he just made it very clear to us that that's what we voted on.
Vote again.
Vote
We're in the
again.
midst of voting when he asked the question.
Okay, with Mr. Glandorf's addition to his recommendation and the motion presented by Mr. Cockcroft and Ms. Jones, all in favor voice by saying aye.
Aye.
All opposed? The amended motion carries.
Hey, let me make sure I got this right. So we're going to, the attorney's going to take another look at this. It's either going to be $500 per month that we find that there was activity, or we're going to close this complaint. And we're giving him the authority to go ahead and do that without bringing this back to the board.
That would be correct.
Thank you.
The original complainant, will they get a response, do they not, or the?
Yes, they get a notification of what the decision is, yes,
If
sir.
we have an address.
Do, because they're-
Got a detailed enough complaint, surely they've,
I'm pretty sure it was filed anonymously with a lot
Oh,
of detail.
okay.
Well, if it doesn't, but if they,
all right.
anonymous complaints obviously do not get notification, but. the
Anonymous
are-
complaints kind of hard to respond to, aren't they?
Just give us a moment, please.
We're gonna take a 10-minute recess. Yes, would you please? 15, let's do.
Well, we've got a 10:30 appointment with the.
This March the 19th, 2015 meeting of the Alarm Systems Contractors Board. Go ahead, Ms. Fest.
I'm going to interrupt our legal report, please, to introduce our new Assistant Commissioner, Brian McCormick, who is going to talk to us about the alarm budget.
Great. Thank you, Director. And good morning, Board. And
Welcome.
thank you for, so I want to make sure, does everybody have a copy of the 14 close? Okay, great. So this is last year's budget close document, and I'm just going to kind of overview the document, and if you have any questions, please feel free to chime in at any time. First, looking at as we look at the expenditures, you can see. I think I'm just going to look at grand total here. We have $380,834. Looking at payroll expenditures, they're down a little bit from the prior year, and that's based on a kind of calculation as staff. And if y'all have any questions about how that is distributed, I should have said I've got Bill Huddleston here with me. He's the accounting manager for the division.
Hello.
But that's really been related to how we distribute the salaries that are shared between some of the programs. That's why that calculation's a little lower this year. Looking at travel, it's basically consistent flat from the previous years. I'll draw your attention to one expenditure here, which is the third party and professional administrative services. There's a $20,000 charge there, and that relates to a one-time expenditure for PSI.
Or the PSI being the test. Okay.
That takes you down to a grand total of $380,834, which is lower, and I think that's mostly reflected in that redistribution. At your total expenditures for the year, it's down also from previous 2 years at $599,130. Your cost backs were a total of $218,297, which takes you to that $599,130 number. Licensing revenue for last year was at $784,223, which takes you to a net your final fiscal year balance after is at $217,892, which adding to your prior fiscal year balance, fiscal year reserve of $749,770 takes you to a current reserve balance of $967,669. So,
What is the core expense I see that's listed only for the last fiscal year?
We're currently using a licensing system called RBS, which was purchased, tell you, in the McWhorter administration. It's been around a while, and so it's DOS based. We've been trying to update that system, and so that's your all's portion of the cost. We've spread that cost across all of the boards. We're taking that out of the reserves of each board, and that's where that expenditure is coming from. One-time expense, it's being split over 3 payments, and what percentage is this?
This is 75%.
So we've got 3 more years of core expense to come out of our budget, correct?
Two more years.
2 more years.
But that 56,000 is the bulk of it. It's 75%, approximately 75% of it.
Thank you.
Yes, ma'am.
Anyone have any more questions for Mr. McCormick or Mr. Nelson on this? I think there was a change too on the license renewal. We brought some of the categories into accordance to where they were coming in. We changed the periods, what I'm trying to say, on the renewal. Didn't that? I thought there was some issue that
become effective yet.
Oh, it hasn't?
No.
Okay.
No, those are still in the rural processing. that our attorney could be glad to speak to you concerning.
I just knew, when we had a meeting with one of the senators on this, and I knew there was,
Yes.
maybe it's still just a proposal, but I remember that being specifically addressed with him about the renewal periods and bringing things into some.
Right, well, actually what that is, and it is in a new rule, is for your registered employees they already get their own badge, but they do not have an expiration date. Now with the new rule, they will be getting an expiration date. All registered employees will renew every 2 years. As we take it and merge everybody over, they will be given the same expiration date as the company, but as
That's what it was.
That's
There
what
was-
it was, yeah.
We were bringing everybody into accordance, and I guess it
Yes.
was the employees with the company instead of people having a lot of different expiration dates. It was gonna be like a common,
Right, as we
renewal date.
reload and put them over into that category, it will be hinged all on the expiration date of the company. But after that, as they transfer or hire in, there will be different dates from the company. Of
Okay.
course, it's a 2-year license. But
Thank
that's
you.
still in the rules.
right? Anything else for us?
All I have today.
Thank you for your appearance
Thank
and
you.
explanation too. Do we want to go back to the legal report at this time?
Yes.
Not that you want to, but we have to.
No,
I
this
think
is
we
actually a
were,
good
I think
experience.
we,
This is good. I think we're at number 17.
I agree.
Okay. And I've been receiving some updated one on one that I would like to go back to, but I would like to just carry on to the end, and then we'll go back if necessary, if you all do not mind. Case number 2015000201 and 2. This complaint alleges that Respondent 1, who is an alarm security company licensed in Tennessee, engaged in a joint venture with Respondent 2, which is a North Carolina company that's not licensed in Tennessee, in violation of 6232304E. It appears that Respondent 2 subcontracted with Respondent 1 to service and inspect alarm systems in an East Tennessee child care center. We received a letter from them. This is an updated information that they have now terminated that contract. And as such, our recommendation was authorization for a formal hearing and to send a consent order to Respondent 1 with a civil penalty in the amount of $500, and also to authorize a formal hearing and consent order to Respondent 2 for a civil penalty in the same amount of $500 for their unlicensed activity.
Let me ask a couple of questions here, because I'm really not sure that I understand fully what the situation is here. Was the Respondent number 2 the company that was actually doing the work in Tennessee?
Yes. Let me confirm. I'm going to say yes, but I'm going to hold it there for just a minute if I can. It is.
Respondent 1
Yes.
was licensed in Tennessee.
Says Respondent 1 was the licensed company, but they hired a North Carolina company that is not licensed to do the work.
That's correct.
And since then, that contract has been.
If that's a correct understanding, that the licensed company subcontracted the work to an unlicensed company.
Yeah.
Okay, I just, like I say, I was trying to make sure I
So,
understood.
I apologize. The unlicensed company was hired to perform annual fire alarm and extinguisher inspections and services and maintenance to a facility in Maryville, Tennessee. Their contract the contract that the licensed company signed with the unlicensed company said that the unlicensed company was supposed to be required to be licensed in all states and performing all services and such. And when they responded back to us, they said, we assumed that they were licensed. It was required in the contract. Because of your letter, we found out that they are not, and were not, and so we've terminated that contract with them for their breach of contract.
All right, Madam Chairman, I make a motion that we concur with the recommendation of our council.
I'll second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Number 18, case number 2014027151. Here the complaint alleges that the respondent qualifying agent failed to list 2 registered employees in the company's renewal form as required by Tennessee Code 6232-317D and Rule 90-0.069K. The board staff received the renewal form on September 12th, 2014, and have not received any termination notice until this date. Although the respondent has a previous complaint, it was not for this type of offense. We recommended the authorization for a formal hearing and consent order with respondent in the amount of $100 for the violations of 6232-317D. This amount represents $50 times 2 employees.
I'll make a motion to concur with council.
I have a question. What was the period of time that they worked there? That they were unregistered?
Still
They
registered
they weren't terminated, is
He
right?
never did terminate him. He
Registered, but he
just didn't
didn't
list them on
terminate
his renewal.
Did we get a response from the qualifying agent, or did we?
Let me look.
They were. I mean, they could even still be there, and it was an oversight to list them, or. But we still don't have a termination, right? They've not received.
That's the renewal form. Yeah, thank you.
Turning pages, just if you give me just a moment, please. Well, I do not have a response in here.
Yeah.
I do not have a response in here. It appears that they left them off of their renewal notice. I believe the assumption is that they have terminated them because they're not on the renewal notice.
Right,
Is
but
that
we didn't
correct?
get termination notices.
And we did not get a termination notice, so they're in a limbo status of we're not licensing them anymore, but generally when we don't do that, we have a termination notice to show that.
Right.
So they in fact didn't respond. They did not respond. We sent this to them. They did not respond, and that's not listed in there. I apologize, but they did not respond.
Shouldn't a penalty be assessed for non-response?
It would, and it's generally $100.
So I need to amend my motion to recommendation of council,
I think we have a motion, but no
Did not.
second. Oh,
but I didn't add that.
well, let's let Mr. Glendorf modify his recommendation and then
Did that my
let it die for lack of a second, and then he can modify it.
I would amend our recommendation for 2, so that it would now be authorization for a formal hearing and a consent order to respondent for a civil penalty in amount of total of $200. That would be $100 for violation of Tennessee Code annotated 62. For the $50 per the 2 employees that we did not receive a termination notice on, and also I would recommend a $100 civil penalty for failing to respond to the complaint under I do not have the rule
Rule
listed, but I will
18.
find it. Thank you.
It's Rule 18.
I think we had one in a previous legal report, but
number
it's hard to go
15.
scroll this.
It was
fast.
complaint number 15. It's Rule 0900-01-0714.
Failure to respond for against rule 090-01-.07 parenthetical 14.
Okay. Now, do we have a motion on the council's recommendation in this matter?
I'd make a motion to agree with our council's recommendation.
Okay, we have a motion, Mr. Cockcroft, based on the amended recommendation from our council. Do we have a second?
Second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Let me make sure I got that motion then. So what we were doing, it's $100 for the violation and then $100 for no response. So it's
That's
a total
correct.
of $200.
Yes, ma'am.
And that was made by Scott and Jones.
Correct.
Yes.
Okay, I had it.
And you, at this point, are the employees terminated? Do you terminate
We
them
don't
based
know.
on the, because we still don't really have a response on
Yes, they
that.
haven't
weren't put on the
responded, so
renewal,
we
but we
don't,
don't
yeah.
know what their status is.
It's one of the
if they're-
reasons we're glad we're gonna be getting the registered employee renewal, so all companies will know who is employed with them. If you would, for just a moment, we'd like to cut into our legal report again, because our Deputy Commissioner, Bill Giannini, is here to speak to you for a few minutes. Bill, if you would.
Good morning, Chairman and Board. Good to see you all. I think Tony is going to pass out some information for you. We were asked last year to submit to the legislature an analysis and a report on all of our programs regarding the efficacy of creating an apprenticeship program for each professional license in the Division of Regulatory Boards. A number of those programs already have apprenticeship programs. There was a larger number of them that did not, and through our analysis, there were a number of them that would not ever be eligible for one. However, your board, the Alarm Contractors Board, was one that we concluded that could offer an apprenticeship program for your QA license. And so this is the section of the report that was presented to the legislature involving the Alarm Contractors Board. And we wanted just to come before you. I think it's something certainly that the board should consider adopting. If you want to have a discussion about that and maybe consider, at your next meeting or several meetings down the road, certainly you may have some questions, that legal questions you might need answered. And I certainly don't want you to make a quick decision today, but it's something that I would like to have on your radar and give you all an opportunity maybe to digest it and then come back at your next meeting prepared to possibly have a discussion about it. See if it's something that you would like to do. So, have some.
Yes, I could go through an overview just so that you don't have to read all three of those pages. You could just take the information that I give you and digest it with that a little bit further. But this analysis basically looked at and identified that you all, under your qualifying agents, under your statute, it basically says that, and you have a rule that is associated with this. It says an applicant, in order to qualify for a license, the applicant for a QA could hold a current certification by a national training program approved by the board in the field of work to be installed, serviced, or monitored and have at least 5 years of working experience in the alarm industry covering the actual installer's alarms. So that's your statute, and you all have a rule that basically says for approved courses, it's Rule 90-03-.01, and this is the text of your rule. It says, for purposes of licensing qualifying agents, the board shall determine on an individual basis what courses are to be accepted as national training programs. A nationally recognized training program is not required to be offered throughout the nation to meet this criteria. It may consist of proprietary information of an alarm systems contractor as to how its alarm systems are designed, installed, monitored, and have enrolled restricted to its employees. The board should have the authority to determine on an individual case-by-case basis what training programs are to be accepted. So you all already accept training programs. You can. For the licensing of a QA in lieu of all of the other educational requirements. You all have passed a rule saying that they would come before you on an individual basis and you would determine whether or not this would qualify. Because of we've been charged now to look and see if there are apprenticeship programs that could be offered throughout the boards. This report that you have in front of you basically identifies and it provides a way that the board could use apprenticeship programs under this rule. Basically, to boil it down, there is the National Association, there is an electronics Security Association, which offers a national apprenticeship program, and this is offered. It says it is offered through the Tennessee Electronic Security Association, and it allows for a 4-year apprenticeship program. And it has, on page 2, it lists what those requirements under the program are. And the idea would be that it's possible for you all to consider passing a rule saying basically that you all would recognize the completion of the Electronic Security Association apprenticeship program as a national training program for a QA license. Basically, right now you have it on an individual basis. The rule would say we would recognize this program for anyone who completes it. In the way the implementation of this program is really not how would this be implemented? Our understanding how it would be implemented, and it's in the document there on the bottom of page 2, is that basically an alarm company could find an employee who they would see as having some potential in the future to be a QA, and in lieu of them going through all of the normal traditional educational requirements, that this person could be a registered employee at this company, and then they would go through this apprenticeship program based on this national criteria. And then over the course of the years, when they finished that criteria, they would come before the board, and the board would say, you have finished this national criteria basis. Yes, that will qualify you for a QA license. I do not know how you all currently do it or how often it comes up. But it seems like this is a very easy path where the board could say, by rule, we recognize this apprenticeship program. And if you all did that, you would be in conformance with this new idea of boards and commissions that could identify to have apprenticeships.
Eliminate some of the other testing, or I mean, is that is the education and experience requirement, or?
My understanding is that this apprenticeship program would encompass all of the testing that is necessary. Let me look and make sure.
The apprenticeship program is really intended, and I have some degree of familiarity with it, and Scott may well have some familiarity with it as well. It's really intended towards the registered employees rather than intended towards a qualification for the qualified agent. So it's really intended, that apprenticeship program is to bring people with no experience into the alarm industry, which is really the intent of the apprenticeship program, and I think the intent of what the legislature is asking boards to do, to allow people from outside the industry to come into the industry, and that would do that. It's really not intended to focus towards qualified agent at all. But once a person has gone through that program, then to take an additional class, and we've approved several of them, for the elevated level to become a qualified agent, they've gone through this apprenticeship program, then they're pretty well going to have met the experience requirements. So it'd be just a matter of taking an additional course and making application for qualified agent. And if I would understand it, I think the apprenticeship program really meets what the General Assembly intended. I'm not sure. Maybe this is some clarification would be appropriate.
And what are the requirements now for the QA as far as experience?
Right now, there's 3 options. The applicant must hold a 4-year baccalaureate degree in electrical engineering, industrial technology, computer engineering, or industrial engineering from accredited university or college acceptable to the board with at least 2 years actual experience in the alarm industry. The applicant must hold an associate's degree in engineering technology from accredited 2-year technical college acceptable to the board with at least 4 years of actual experience. So those are the general 2 educational. It looks like it's a 4-year degree with 2 years of experience or a 2-year degree with 4 years of experience. The third item talks about holds a certification by a national training program approved by the board, and it must be 5 years working and experience in the industry. So this is what we're talking about.
We've got a number of those programs that have been approved, and basically short-term programs. Programs would be a week perhaps. So a person that has gone through this apprenticeship program to become well qualified in the alarm industry. So somebody outside the alarm industry could come into the alarm industry by virtue of this apprenticeship program and then would attend an additional class that's a higher educational level to bring their education level up to the standard necessary to be a qualified agent. So they after they've gone through an apprenticeship program, they take a week class, they take an exam, and they become a qualified agent. So the step from a registered employee to a qualified agent requires that they know what they're doing, because it's a high degree of responsibility, but it's a very easy step, and there's not any barriers other than one of, and I don't know how many classes we've approved, probably a dozen or more, I would guess, that are readily available. So they take a week-long class, pass the exam, and fill out the application. So there's not any real barriers. So I really feel like the apprenticeship program meets the full intent of the General Assembly. Would be my opinion.
Well, there's one line that says additionally that ESA apprenticeship could be considered by the board as qualifying education. But I think what you're saying is we kind of already have an apprenticeship, but we still require another course.
Yeah, and for example, the apprenticeship and just to give you a hypothetical case, the apprenticeship program could take someone from outside the alarm industry, bring them into the alarm industry, and give them all of the necessary training. They would be fully qualified to install burglar alarm systems, or perhaps a fire alarm system. But still, that they may not have any experience for instance, in the monitoring area. But a nationally recognized training class, again, most of those are a week or less. Some of them are as little as 3 or 4 days, 3 days, I think. Would be a course to make sure that they have, the education in that particular field. So, I really feel like that we've got an apprenticeship training program is intended, but the step from a registered employee to a QA takes a short course and passing an examination.
Right, and I think the only other actual time requirement is the 5 years.
Well, if he's done 80,000 hours, he's going to
8,000. Yes,
8,000
right.
hours.
And that's what I was reading in this. So
Yeah.
it appears what I'm hearing you say is that this program would be one program that could be done, but what I hear you saying is that there are other programs that you have recognized in the past, which essentially does the same thing.
Yes.
That you currently recognize.
Yeah.
So we could put that to the rule. Is my understanding is that we could put those programs that you've already recognized to the rule, and something like this could be in addition to that.
I think the only thing that Ken's saying is they would still need to take the additional week or less training that would get them over the hump from registered employee, well-trained, to qualifying agent testing. Not just grandfather them in because they've completed this ESA, but there would still be the requirement for that additional training for the QA.
The ESA course is just like a 2-day course, and you take someone off to the street and put those through the TNESA course, the NTS Level 1, and that qualifies you as a registered employee, and you, for the lack of better words, walk along beside a QA for X amount of hours or take more education, and it will qualify you to become a QA. But an NTS Level 1 right off the street is not going to qualify you to become a QA overnight.
I think what the intent of the legislative intent was to say to all of our professional boards, look at your current requirements, tell us, is there an opportunity for you all to extend to people basically on the job training, give them an opportunity to get to work, working under a reputable company, and to be paid while they're training, and then be in a better position to move to that full licensure step. In your case, it's a little unique because of the QA is a different scenario than most licensure programs?
Let me, in a sense, let me maybe give an example. And I really think the apprenticeship program that's set up here meets the intent, fully meets the intent of the General Assembly. But that'd just be an opinion. To give you an example, for example, let's take a brick mason. You take someone off the street, they would go through an apprenticeship program to become a qualified brick mason. And that would be similar to the intent of the General Assembly, I believe. And the apprenticeship program we've got here would do basically the same thing. Now, again, to follow the brick mason example, even though a person was a brick mason, an apprenticeship program would not necessarily make them qualified to be a business owner.
Right.
And the qualified agent is a significant step up. That's not difficult to achieve with a little bit of added education, and because they would have already, through the apprenticeship program, I would feel like have gained the necessary experience without a problem.
I think, I mean, by definition, primarily an apprenticeship is intended to be in lieu of education, on-the-job training to work you towards a degree or the license or the ability to test. And it may not be, you know, you guys may decide again that this doesn't make sense for you. We wanted to put it on your radar. We believe, based on our analysis, you're empowered to extend the option of apprenticeship to licensees. How the particulars of that, I think, would need to be worked out through these kinds of discussions, and with your legal folks. And so again, it's wanted to get it on your radar, something for you all to consider.
And I would like to see an apprenticeship program, but I do think it applies more to the entry level, getting them to the registered employee position. Right now, the registered employee requires that they have level 1 training within a year, which somebody could be an apprentice possibly for several years without getting the level 1. I mean, that could be some change that we made, because right now there isn't really an entry position. They've got to, within a year, be that level 1 employee. Right now there's an issue with, if you've got a prevailing wage job, it may eliminate some people from being able to work in those positions because they're not the fully qualified employee already. But with an apprentice program, you could have a helper type position on a prevailing wage job.
That's really what this apprenticeship program is intended to do. Yeah.
It should be for you all to have an opportunity to try people out, and it should be an opportunity. It should be encouraging people to get into the profession.
Right.
I mean, it's not intended just for the apprentice. It's also certainly to be a beneficial tool for the business owner and to encourage people to advance your profession. And so we want you guys, and our analysis we are not saying this is complete by any stretch, and I think you all can have a discussion about it. There may be ways that were not considered here by you all, that we just may not having the industry insight that you all have. There may be beneficial ways for you to apply apprenticeships in lieu of education that we have not considered yet, and we certainly would be welcome to that. I can tell you that the governor and the legislature both are very supportive of any professional regulatory board in the state looking toward apprenticeships and encouraging people to earn on-the-job training, get paid while they're working, and so anything that you all can do in that vein is greatly appreciated.
What's the process that we do? I mean, does it have to go back to the?
No, we'll probably need to discuss it as a board, and but you bring up an interesting point. One of the things we could do is accept this apprenticeship training program in lieu of the level 1 requirement. That would could certainly make sense. We need to talk about that some more.
Sure.
Though. I mean, it's something.
And again, we didn't expect you to reach all your conclusions today, but we wanted to put it on your radar. We think you guys are a prime candidate for discussion of it. You are empowered to do that, and you have the authority. And you would be actually the first program in the Division of Regulatory Boards, if you were to agree on some language. You'd be the first professional licensing program in our division to add an apprenticeship program post-report to the governor and the legislature. So that would be exciting to us, and I think to Cody, and you guys just let us know if there's anything we can do to help you. Your legal folks are certainly here, and your administrative folks are here to answer questions for you throughout the process. Always be cognizant of the Sunshine Law, and but we appreciate you very much, and I think it's potentially an exciting opportunity for you. Encourage people to get into your profession.
I think I think we're close to what the intent of the General Assembly is, and I think that if we discuss this, we can work towards that. I'd be pretty optimistic that we could do that.
Great. All right. Well, thank you all. Thank you for your time.
Thank you.
Okay, we're gonna go. Would you like to go back to the legal report now, Madam Chairman? And
We need closure.
say closure. Yes, thank you. And we can each meeting we can bring you information framework regarding the apprenticeship program and whatnot, so that we can have more discussion. So
I
thank
really
you.
think we've got the requirements pretty well in place, but we can discuss that some more later.
Yes, I think it may just be putting it down into words, and then we could be there. Okay, so I believe we are on number 19 now, which is case number 20140311851. Here the complaint alleges that the respondent is a security company by and through its qualifying agent failed to register 12 employees within 30 days. All applications were received on November 14th, 2014. And as we go down there, I will not read these that are on the board because they're so lengthy. But all of these license numbers and all the hiring dates are there. And we have confirmed that this company was licensed during the entire period. So all of these months would count. So in response, the respondent states that they realized they were not in compliance and are making efforts to correct this problem. Respondent states there was a substantial change in management within the company and a new management teams inherited this problem but are working diligently to correct it. The respondent states they understand that there may be disciplinary actions and they do ask for leniency as brought to the attention of this matter to make every effort to correct this. Our recommendation, we base it off of the civil penalty chart that we go by, and we did recommend authorization for a formal hearing and a consent order to respondent to pay civil penalties in amount of $17,500 for violations 6232312D, and that does represent the $50 per month times we have calculated 350 months.
Madam Chairman, I make a motion we concur with the recommendation of council on this issue.
Okay, we have
I really feel like that we should, I mean, it troubles me when something this high for a licensed company, they brought it to us. I mean, I really wish that we would consider a lower amount.
I don't know that they brought it to us. They responded to it, correct?
We set up the complaint based on these applications. that
Well,
were
they
So
they were
did
attempting to come into
submit.
compliance. They submitted all the applications. They put the true date of hire on them. They weren't trying to hide anything. They're
No, I don't think that, I think the system triggered it, didn't it?
They submitted the applications with their actual hire date. They could have put a more recent date. We wouldn't.
Okay,
a lot
I
of
thought it
people,
was something
a
that
lot of
was
people we go
triggered
back
in-
to and they say, oh, that's not really the date they started in the job, and they're trying to be honest, and I think there's others that we've let slide on similar. It is a lot, and it is.
And if you look at it, it goes back to 2009.
I don't think it's minor, but I do think
We just now realized since 2009, he needed to be registered.
One,
in this problem.
2006.
Yeah.
And then there's sometimes does this company have a QA in place right now? Or is one of these applicants trying?
These are all just registered employees. They
Okay.
have their own qualifying agent.
otherwise the company, the QA, they're current and.
Yes. Mm-hmm.
Do they have a number of employees? Is this significant to the number of employees that they have?
They had very few registered before they realized that none of these people were registered.
That answered my question, I think, though.
You could see 12 people running around with your name on their van and not know they were there.
Well, I think the previous management team that they refer to here probably encouraged that.
So somebody has to pay the piper here.
You know, we're not, I think the response from the present management team probably indicated the company is trying to get their act together and behave appropriately, and I think it's commendable. But still, we have standardized penalty system more or less set up that where we've treated other companies at a $50 fine per month. And so I feel like, it was the reason I made the motion. I felt like it was appropriate in this situation. But I guess I would feel like the company's actions are appropriate for discovering a problem and trying to work with it to get it resolved. But I want to treat this company in the same fashion that we would treat other companies, a similar response.
Well, in response to that, it was so Scott will know, it was $100. And then we came back in and take a look at this and reduced it. We would take the first offense and divide it by half. You remember
Then we
when
just
did
changed
that?
the rules and made
Right,
it,
then we
that's
changed
what
the
it
rules,
is.
and that's when we came up to $50. Just so he'd have some history there.
I'll second his motion.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with the recommendation of our council. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed.
The motion carries 3-1. Ready for number 20 now?
Number 20, case number 2014031781. Here the complaint alleges that the respondent security company failed to register an alarm employee within 30 days of their employment as required by Tennessee Code 6232312D. All applications were received on November 17th, 2004. You'll see that the license number of the employee was hired on September 29th, 2014. This represents 2 months. In response, the respondent states that the employee was initially hired as a fire sprinkler inspector. The information that was omitted from this application should have stated that the employee would only proceed with the activities of a registered alarm employee after his application approval. Respondent denies that the employee worked in the capacity or engaged in activities of a registered employee. We have no other information in the file that would dispute their claim. As such, our recommendation is to close.
Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The next part of the legal report are representation of cases, and these are either cases that we brought back to you that we had previous authorizations from the board attorney, or they're litigation cases that come back to you all. So I'm going to read through these. The first representation is case number 2014026021. Here, the consumer complaint alleges that the respondent company was engaging in misconduct in violation of 6232.319. The consumer alleged that the company's security system was broken and that the respondent told them that the lightning had struck their sensor and that they needed a new sensor. The respondent offered to sell the complainant a new sensor for $380 and insurance on the system for $40 per month. The complaint alleges that the respondent yelled at them and hung up the phone. The complainants wanted their contract canceled. The respondent has no history of disciplinary actions. However, they did not respond to the request for the response sent to the board staff. You all previously previous recommendation was to close in regards to the contractual claims as it appears that this was a private contractual matter and that we and for the authorization of a civil penalty amount of $100 for failing to respond. You all concurred with that. There is an update, and the only reason we're bringing this update is because I have talked with the respondent extensively on the phone. The respondent rigorously denies that they ever actually received our complaint letter from the board. They state that they did not get it, so they did not respond that they did not get it. However, the letter was unclaimed from the post office. They state that the first communication they had was the letter containing the consent order. So our recommendation here is not to change it from the original to close the complaint as to the contractual allegations and to keep in place a civil penalty for $100 for failing to respond. I spoke with the company owner yesterday extensively. I had it on my computer. He sees the letter that says unclaimed. They said they didn't get it. I don't understand. It was dated December 27th. I don't think I was at work December 27th. Maybe they weren't. It's really during the holiday season, but we have proof that we sent it, so.
Madam Chairman, I make a motion that we concur with the recommendation of council. I think it's fully appropriate, which would leave basically in place the $100 civil penalty for failure to respond to the board complainant. I might point out to the respondent that if he wants to not pay the pay $100 civil penalty, that we could certainly move forward with a formal complaint on that and have a formal hearing resulting from it. See if he likes that better.
Second the motion.
Excuse me, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation not to alter the board's previous decision in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The next matter number 2, is one that was assigned to a litigator, and we're presenting that on that litigator's behalf. Number 2, case number 2013019-541. Here, this complaint, it originally alleged that the respondent failed to timely register one employee within 30 working days. The employee in question worked for the respondent from March 2013 to June 2013, according to the employee's subsequent application for registration. No response was received from the complaint as to the complaint. Our recommendation was authorization for a formal hearing and consent order for a civil penalty in the amount of $200 plus $100. No, that was the total, $200. And you can see there for unregistered employee and for failing to timely respond. You all originally concurred with that. The update from the litigators that this matter was presented to them to prepare for a formal hearing. In the interim, the respondent's license expired in November of 2014. The respondent has made no new efforts to renew. Therefore, it's actually a moot point to obtain any civil penalty from the respondent who's out of business. But our recommendation is to close and flag if the respondent ever tries to renew. If they would attempt to renew, we would require them to settle this matter with us prior to renewal.
Are they out of business, or did they just not renew?
Well, that's difficult to determine. And let me think off the top of my head, and let me see if I have it in the file, because I understand your question is that it's not if it's an unlicensed activity issue, maybe a bigger issue than this.
Well, I mean, if they didn't renew,
Well, they're gonna have to reapply. It doesn't make any difference.
Can we not, I mean, can we not still leave what we had in place, and do they not still owe that, or just the
If we
fact that
can
they're?
find them, yes, we can go after them, if that's what you're asking. We
well,
can
would they not,
consider that.
if they closed or if they didn't reapply, would they not, I mean, we're all assuming the business closed down, would they not send the termination notices in if they had other registered employees? A one-person
All
business.
company.
They got their license, and it expired 2 years later. They really did.
Will have to reapply. If they do reapply, that it reopens this complaint. They must satisfy the complaint before they'll be issued.
This is our correspondence to them, so it's all come back
All
on
comes-
claim.
comes
So
in.
in order to have a formal hearing, we would have to
Find them.
serve the company.
They could reapply under another name.
Well, the qualifier is the owner, so he's expired too.
Madam Chairman, sounds like probably our best course of action is to go ahead and close this, so I would make a motion we concur with the recommendation of council and flag the particular application and the applicant.
Can we flag the qualifying agent as well? I mean, so that if,
The owner.
right, but it's so that if, he shouldn't be able to be licensed even as a registered employee with somebody else if he hasn't.
Yes, sir, we can do that.
By name and by
That's in your
company.
motion to, you want me to flag not only the company, but
Yes,
the
that would-
qualifying
that would-
agent as well, in case he does come in? Or he may want to, if he goes to another company, and like
I
Ms.
just
Jones
said
was
company or
saying.
individual, and that
Correct.
kind of covers everything.
That's really where I was heading with the motion.
Okay, we have a motion by Mr. Roberts to
Second.
concur, a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Third one is case number 20140140149112. The complaint was received from the Governor's Office and Consumer Affairs alleging that Respondent, which is a monitoring company, buying through a door-to-door salesman, employed misleading information to sell the complainant a new contract. The complainant stated that the system was installed by an unlicensed installer and that her system does not work because complainant does not have a landline phone. And when the complainant requested removal of the system, respondent advised her that she would have to pay $1,800 to have her bank account frozen. This complaint is related to a previous above referenced complaint. Respondent here, and this was in a previous legal report. So the respondent here is the unlicensed company. This is the update, is that Respondent 1 in the first matter paid the $2,500 civil penalty and signed a consent order at the time of the installation for the first matter. Respondent 2 is not licensed but did become licensed a few months later. Additionally, when first notified about the license issue, which was as a result of the original complaint above, Respondent 2 paid a $1,000 civil penalty for not being licensed and then secured that license. The company involved with the sales issue in the first complaint was to be acquired by Respondent 2, but that deal fell through. Respondent 1 then assumed the monitoring services through its relationship with Respondent 2 and ultimately canceled the contract from the complainant. Respondent 2's paid penalty for being unlicensed is related to this matter and promptly became licensed. So our recommendation was to dismiss against the complaint against Respondent 2 because, given the course of facts here, it's actually a redundant type complaint that has already been resolved.
What brought this back to the board's attention? I'm not fully clear on this.
It had been assigned to a litigator. This case was, and so this update is provided from the litigator, who was actually assigned this complaint.
Is there any more pending action since that Respondent 1 and Respondent 2 paid the civil paid? Is there any more pending action?
They already paid their civil penalties, so.
That's what I'm saying. Is there any more?
Both Respondent 1 and 2 paid a.
Already paid.
Right,
And
so
they
what?
need to get licensed, and they did. That's why we're saying. that's why they-
Council's recommendation is that we close this matter because it's coming back up the second time for some reason that we really don't know why it did, but it did, and so now you're recommending we close it. I make a motion we concur with the recommendation of council and close this issue.
Well, is the issue that there's still a consumer that's having an issue with them, that they haven't resolved the issue with the
They
consumer?
resolved the consumer's issue.
Okay.
They took care of that.
It is confusing why it came back. It's like we're missing something. 'Cause I'm fine with closing it as long as
Well, I think it's kind of like it should have been administratively closed by the state and the
On both of them,
computer
right.
when the civil penalties were paid by Respondent 1 and 2. And there's really no pending action by the board necessary other than to say we make a motion to close it, which we have a motion by Mr. Roberts, second by Mr. Cockcroft,
I'll second.
By me.
second by Ms. Jones. All in favor, voice by saying aye.
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 Matters closed.
Can I ask a question? His
Certainly.
recommendation was to dismiss. Your motion was to close. There's a little bit of a,
I mean, I don't know what we're dismissing. We're closing it because all of the actions have been fulfilled.
Well, you're saying there's somehow or another a second complaint's coming up, and it's, well,
But there's
from
a
the governor's
yeah.
office. Something else came in from the governor's
The
office.
difference we have here is between
It was
the word
originally
closed and dismissed.
receipt from the governor's office, I
What we're
believe.
trying to, it's what,
Ma'am.
there's an issue is the terminology close versus dismiss. If you dismiss this complaint, it can never be brought up again.
No, I think we closed it,
So
just,
you want, but he's saying dismiss, that's what recommendation was, dismiss. If you say to close it, that means if if another complaint of this nature comes up against either
I'm
one of them, we
sorry,
can reopen it.
it's like an orphan on the last page. I didn't see the dismiss. I was thinking it was wanting to be closed.
That's what we're trying to determine. Do you want to dismiss it or close it?
My motion was to concur with the recommendation of council,
What is the difference?
as I recall. So that would dismiss it.
Okay.
I may have said that we concur with recommendation of council and close. Well, if that doesn't cover the waterfront, nothing will. Yes, we voted in the affirmative,
All right, then we do.
and it was declared
Dismiss
passed.
it. All right, thank you. I didn't.
Okay. That concludes the legal report, I believe.
We're gonna go back to a few more, Madam Chairman.
oh, that's
just
right.
We
Okay.
skipped something.
we've skipped one, and I apologize that we
It's
had to
okay.
skip
Which
one.
number do we need to
And
go to?
we are going back now to number 7, and we have updated numbers for you. So I will not reread all of this information in here. I will just give you all the update that if we look, if we look at the numbers from 1 through 7, we recognize on the first line that it was 3 months, and that may have been more. So what we have done is we have discounted, best word for it, discounted the length of months from the times that the company was actually licensed and working in Tennessee. So if we do that, then for number 1, the total months is, in number 1 we had failed to add in the 12 months, so it should have been 15. But if we discount it for the amount of time they were actually in Tennessee, it's 10 months. For number 2, 10 months. For number 3, 9 months. For number 4, 10 months. For number 5, 10 months. For number 6, 5 months. For number 7, 4 months, which is a total of 58 months. So of this activity. So our recommendation is authorization for a formal hearing and a consent order to be sent to the respondent to settle for a total amount of $50 times 58 months, which is $2,900 for violations of 6232.312D.
Motion we concur with council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation in this matter for a civil penalty of $2,900 and authorize a formal.
Second.
And we have a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
And Madam Chairman, there was one other item that was slid past me as we were doing this. I believe it relates to number 15 on the report. Let me look at this. On number 15, we had changed the recommendation, and you all voted to accept, to change it from $750 to $650. And because that they did respond. I was made aware that in the response, they're actually stating in the response that during the period that we allege here that their employees did not have access to any Tennessee customer information. As they say, our systems are such that they are compartmentalized and restricted to those employees who have been approved for licensing, and it applied to these employees also. They're actually out of the state of Utah, so therefore, based on the information that we have in front of us, I really don't have any actual evidence of these violations, and therefore would recommend to amend my previous recommendation and recommended recommendation to close the complaint on the new information I have.
We know what the employee's job duties are.
It's a central station.
National Guard offices is what.
Yeah.
Okay. They say here that they were and still has not been given access to Tennessee customer information, that these employees.
So the employee application was sent in, but as we've seen in other cases, based on the employee's employment date, but that employee was not engaged in any sort of work associated with Tennessee. Therefore, okay. Madam Chairman, based on the recommendation of council, I would make a motion that we revisit the previous case and, as a result of the revised recommendation of council, close and dismiss it.
Okay.
Close and dismiss.
Tell us the difference again.
Well,
It's
dismiss, distinguish it. The dismissal would extinguish the complaint. It's almost an adjudication. We have now dismissed this complete complaint. Closing means that we are not taking action at this time. We actually don't. We close for whatever reason, but it could come back. There's actually not. For most programs, there's not any statute of limitations on any issues here. So the state, for most programs, I believe it includes this one, is that they could go back and reach back years and years and years ago, even on a closed complaint, and we could bring it forward. But if we dismissed it, we have quasi given an adjudication already. And so once you make a dismissal, there's a strong legal argument that we would never be able to have a formal hearing in the future. And in the previous case where it's a duplicate complaint, we're dismissing a duplicate. We have an underlying original that is good to go. So the closure is just it gives us options in the future. Dismissal does not.
I need to distinguish which one we're.
I recommend to close this complaint.
Make a motion. We concur with the revised recommendation of council and close this particular case.
Okay. We have a motion to concur with council in the recommendation to close this case. Do we have a second? You made a 2nd
I'll second.
Okay. And a second, Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. I couldn't remember if you did before you wanted to.
Madam Chairman, that concludes the legal report presented to you today from legal counsel. Thank you all for your patience, and I appreciate everyone's assistance.
Thanks.
Are you're going to go over the proposed fingerprinting rules?
Yes, Madam Chairman,
also?
on the proposed rules. What I provided to you all is proposed rules that has a lot of language in that, and I can assure you that the language of that rule is not 100% all of the language that we would use. It is a guideline language, and just to be upfront, what I would be looking for today is for the board's authorization to have a rule substantially similar to the language that I've given you regarding fingerprinting. I would be requesting a vote. And to give you all an update about rulemaking.
They haven't seen that either.
Okay.
Yeah, these go together, but they haven't, that's the first one.
So it's all.
And everything.
Okay, so this is all new to you. I'm finding out. So just to update you on kind of how rulemaking works now is that there are more options on rulemaking, wherein that we can this board could today. This is an example. It could say we would like the rule that says X, Y, and Z. And once I get your authorization to do that, and we look at a couple other things, we could, after the internal process is done, we could actually file that rule, and 90 days later it would be effective without having a rulemaking hearing. And the reason why that's done is because there is a recognition that to do a rulemaking hearing on non-contentious rule is kind of a waste of time. We're waiting a lot of time for non-contentious items. So on proposed rules, and this is what we've been recommending a lot of times, on proposed rules are rules that are generally non-contentious. And a proposed rule, once it's filed at the Secretary of State's office, will become effective in 90 days unless 25 members of the public contact the Secretary of State's office and say, we'd like to have a rulemaking hearing on that. So there's a catch-all. There's a check and balance system there. So, so that's an update. So we've been pushing these proposed rules when they're going to be non-contentious rules. So what we're bringing you to today is a matter regarding the board's usage of fingerprint cards and the submission of fingerprint cards from applicants. And Cody, would you like to give like the overall? She'll give you the background of how this has come up.
All right, I've told you about previous meetings that the TBI has gone paperless. Well, they have finally notified the agencies they will no longer be accepting hard cards. We are not allowed to send any more hard cards to the TBI. So what we're proposing is to have all fingerprints taken electronically. That is what other states have had to do, and that's what the TBIs, I don't really have an option here. They're going to have to be done electronically. Now, there is a transition period here. We are still getting in fingerprint cards. I cannot submit them to the TBI. We must go into the TAP system, and we must, L1 Morpho Trust as it's called, key from our computers just like we were the applicant sitting at home. We have to do this work for them. We will have to take and do a spreadsheet with their names on it, social security numbers, whatever, and with the hard cards, box them up, send them to Illinois for L1 for processing as well. So all that's going to be done in our office until we get this final transition through. So what if you'd look at what Tony was saying, your proposed rules for fingerprinting is B, and you also have H. H actually explains to you, we got the information in from the TBI. It's notifying me that they will not accept the hard cards. Then we have the revised fee schedule. There's several things that they're doing. They're taking a TBI and FBI applicant fingerprint check was $42 and now has been reduced to $38. It's actually going to be cheaper for the applicant. What happens is if the applicant is at home or at the office, whatever, and they get into Morpho Trust and they do all this keying, the information, they make the appointment, they have the prints done. I have that report back before I can process the whole application. It's that fast compared to, what, 6 months, 3 months, whatever, with the hard cards. So what we're bringing back today to all our programs, this is everybody who deals with fingerprint cards. We have 4 programs. It also involves the Department of Insurance and several other regulatory boards. Everyone must start doing electronic prints. I do understand that there are companies that are out of state that's already been set up with Morpho Trust. Most of the alarm companies are already doing this, and they're out of state. They know how to do this.
They're actually doing it. Most of our larger central stations are already doing this for several states. They've already got the account set up to do it.
Didn't I get a memorandum through the locksmith licensing program that you quit it already?
Right. You got all programs. You should have already.
Yeah.
If you're the qualifying aid for your company should have already got that notification from me telling you that we cannot process hard cards. So that's what this is. What I just wanted you to put the 2 together, the B and the H.
Do we have any control over who can do the electronic fingerprint portion?
Oh, sir, we do not. That is a contract with the TBI, with Morpho Trust. That is the only company that they've done a contract with. Now, that may be changing at a later date. I don't know. But that's the only company. You had asked me that before.
No, I had asked there's somebody in Memphis that does a lot of fingerprinting, and she does all cards. She doesn't do any electronic. She said she can't do the electronic, though.
Alva.
Yeah.
They wouldn't approve her to have her own L1 location.
No.
She told me that, but I don't understand entirely what she was
Well,
saying.
the
but
they,
it was-
L1 or Morpho Trust has been in the state of Tennessee for several years. It's just now that the TBI is going to mandate this. The L1 says they will be within a 50-mile radius of any employee, so they've already got their machines all set up. Department of Education, bus driver, whatever.
A lot of them are in the
all
Board
of
of
already
Education
right.
offices. Some of them are in the guard training offices.
So I
like
do
in
have
Memphis.
companies that are asking me about purchasing the machines so they can get in with L1. I just refer them to the TBI and to L1, Morpho Trust.
So this company's called, like, the letter?
It's Morpho, MORPHOTRUST, Morpho Trust. And the program is the L1 printing. We just
So
refer to
even-
it in-house as L1.
So a large company could buy or get the machine and do the
That's
fingerprints themselves?
if that's
Or
acceptable to the Morpho Trust and to the TBI.
If they can,
That's between them.
okay.
Yeah, but right now they've got it set up where you can take one hard card that you've had rolled for your applicant and set up an account with L1, send it directly to Springfield, Illinois, and they'll convert it to electronic instead of sending the card to us.
That's what our attorney is asking you to consider today with the rulemaking.
Well, I was kind of getting, so what you have in front of you under Exhibit B is a document. It says proposed rules for fingerprinting. It's a filing form. This is just the form that I use, but what we had to do is that your current rule right now makes it difficult for us to comply with the TBI. Because right now, your rule, for example, says that an employee registrant application shall either obtain electronically scanned fingerprints on the card, or provide with 3 sets of classifiable prints. So what we have right now is a rule that says they can do either or. Now the TBI is telling us that they're not going to accept any more of those cards. So if we get a card from an applicant, we have to do it. Well, we don't want to do it. We want to push it off on the applicant. So in order to be able to say that as a board, correct under the law, we need to amend the rule so that they're not allowed to send us the cards anymore. So basically, the rules that I have provided to you is a rewrite of our current rules of all the sections that it mentions fingerprinting. And what we have done is we have amended those rules to take out the option for the applicants to send us the fingerprint cards. But we did leave it in the discretion of the board to accept fingerprint cards almost on a case-by-case basis. This would be for some oddity or whatnot. That is just the caption so that we could forward it to them. If we closed the door for everything, then we couldn't think of one exception. But this is basically going to be the way the rules are written now is to amend them so that, yes, you would have to send us, you would have to go and do the electronic yourself. We don't want to do that. And it's actually cheaper if you do it yourself. So it kind of makes sense for everyone in this area. So what you have before you is a rewrite of the rules, and this is how the rules would be rewritten if you look at them. And I can go through these with you. It's a lot of text in there. I do apologize, but when you rewrite rules, sometimes you're just kind of left with what you have. I mean, sometimes you can change a couple words, or sometimes if you change a couple words, it's going to make it a whole lot more vague than it is, already. So we like to rewrite. So I can go through these with you and basically show you where those changes are going to be.
Madam Chairman, let me offer a motion that we approve the proposed changes and authorize council to file these proposed rules changes to the Secretary of State or with the Secretary of State's office.
I second that.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to accept the proposed changes to our rules pertaining to fingerprint cards and allow him to file those with the Secretary of State's office as necessary. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries. Thank you.
Thank you. And if I could, Madam Chairman, there would be one other thing that I mentioned earlier that we'd have to do on these rules, and I would like to save that for the end of the agenda because what I would bring to you would be very simple. It's called a Regulatory Flexibility Act addendum, and there's a statutory requirement that when we do propose rules that we make an analysis of what the impact's going to be. I'll tell you very easily that there's going to be no issue on the analysis of the impact, and I believe that's somewhere upstairs in my office, and I have to find it. But I will bring that down for you all to look at and then to approve, so because it's required on the filing.
Yeah, we've done those before, and I think we just kind of lump it all together and vote that there's no, I think, is this the one that includes the economic impact?
Yes, it is. It is.
Just kind of lump it all together
Yes.
and vote.
And I
But
can-
no, that'll be fine.
Yes, and I would like to bring it at the end because it
Okay.
should not take very much time because I know you have other things to get to.
Thank you.
You're welcome.
All right.
One thing, it looks like we do have a few things to go through, Madam Chair, so I'm going to ask the board if they're going to break for lunch today.
We're going to.
Back at 1 o'clock?
Yeah,
I've got-
it's 11:54 here now.
There are two people here that we thought the appearances would be around 11.
You're not,
I'm sorry. There are two people here that have come for their part.
what
Y'all
is
wanna-
their part?
I've got a qualifying agent that came back from Knoxville after the last meeting when you told him you had,
Did he bring that paperwork? You know?
he sent it to me months ago.
Okay.
And then I have another qualifying agent who's here for your review of his degree in case you have any questions. If you could get those two things out of the way, then they wouldn't have to sit here till 1 o'clock waiting. That's up to you guys.
You will? All right, we're going to postpone the break, and we will see those two appearances.
Mr. Andrew Bryan is Exhibit J1, and Mr. Rourke is Exhibit J3.
Mr. Bryan, you want to come in and sign in, please?
Applicant, hold on, I'll get his, huh?
Is it a QA?
We're gonna look at them.
Yes, it looks like this one was presented at the December 11, 14th board meeting, and we needed additional information.
Ken, you were not here at that meeting. If you wanted to look at Exhibit J1 to review the experience documentation he had already submitted that, actually it was kind of a tie vote not to approve him. So.
Right there's all we're looking for, right?
Right, Mr. Bryan, you might need to give them a little history on this.
Mr. Roberts wasn't present
He
December,
wasn't present, so,
he's
I
not
mean, it would
aware of
help.
what's the
If-
situation.
I'm ignorant.
If,
Curious.
if you
Help
give
me
a
resolve the
little
issue.
rundown, what happened during the company and why it looks like you had been working and without being registered.
Yes, Mr. Roberts. I was hired on with the company in 2007, and my father was the DQA, and he had me learning the business, and he needed some help as well. Both him and my mother, who aided him in questions with this clerical issues, finances, were both going down in health, and I discovered once he passed that I was never registered from the beginning, and am now seeking to become the DQA for the company.
How big is your company, Mr. Bryan?
It's fairly small. It's myself, my brother is a registered employee, and we have a technician who's a registered employee.
This was a family-owned business?
Yes, ma'am.
And your parents passed away? Is that what happened?
Yes, ma'am. They passed away last year. Mom passed away in May, and my father passed away in July of last year.
He wasn't denying his unlicensed, I mean, that where he worked he's got documentation there that he worked. I think our issue was the employment history, the experience, and
He claimed he had worked there all those years, but
Right.
he had no proof.
Talk into the phone, Madam
But
Chair.
there's
Right,
only
Madam
one.
Chair.
He had
Told him to bring his
claimed that
W-2s.
he had worked for the company
It's on him.
for X number of years, but he had no proof of it. And we asked him to bring in proof of his employment, because he only provided 2007 and nothing forward from that date.
So that's what you're reviewing now?
Well, all I'm seeing are just
There's, I mean, he's-
worksheets from H&R Block. The only
Well,
thing
but
I
if you
see,
look at his job title on those tax forms, doesn't it say technician, electronic or alarm technician? That's what you were asking him to bring.
ask him to bring his
we asked for W-2
W-2s
forms
for
from
the
the
past
company.
4 years from the company.
Apparently, he doesn't get
He has to be
I-
issued
Get a
a
W-2 to
1099
file
or a
it.
W-2.
You gotta file taxes somehow.
Did you provide 1099s or W-2s from the company for the period from 2008 to 2014 that was missing?
I have not sent those in. I can provide those readily by request.
That's what we asked for last time.
I was under the impression that it was the tax records, the tax filing records.
And from the IRS, this is what we want for the past 4 or 5 years. I forget we asked.
the last meeting, I thought you wanted his tax return showing what he had put on there as his profession.
We wanted tax returns from that company, his father's company, where he said that his father was gonna make him pay, but just misplaced the paperwork.
No, he was going to register him.
I register him, but he never did get registered. He's never been registered. These are just worksheets that I'm flipping through. This is the only return. I'm not looking through no more of them.
Okay, so maybe we just had a
This-
miscommunication
Well, I believe
problem
so,
here.
because I think what this shows is that the man was employed for those years, but it doesn't show how or where he was employed, because there are no documents from the security company showing that he was an employee there during these years.
This was
There's
his
one,
father's
that's it.
company we're talking about. Is that right, Mr. Bryan?
My father was the DQA for the company, yes.
Have these tax records? Do you have anything that you provide before the board?
I have the W-2s from I should have the W-2s for the past between
One
2008.
W-2 from 2008.
At the office, I could provide those.
Brought it, why didn't you bring the rest of it?
I had sent in the tax records. I was unaware that the W-2s were the documents that you were seeking.
We were trying to give you the benefit of the doubt that these interim in the security field, because I think you told us when you were here in December that you were actually in the entertainment field. So there was a question that you didn't answer about which years were you working in the entertainment field and what periods were you working for your father's security company. And that's why we wanted the tax records to show your employment was continuous through those years in the security work, but that's not what we have. We know you pay taxes, but we don't know based on income derived from what source.
I was, there's been a mistake. I would have provided those had I been told to.
There's letters from customers, but I guess those just are for the, or your concern is those are just in the last few years or more recent time?
There's a period, I think, from 2007 to current time, he has no proof he worked there. You know, you've got customers' letters, but, you know, regardless, he's wanting us to say, to vote him or to approve him as a qualifying agent based on a customer letter, but yet you have no proof he was actually in the security field. He was never registered.
Okay, so what do we need Mr. Bryan to do for us? Provide the tax records, right? Or W-2s
I think
for this period of time to show that he was in the industry.
Working
That he
in
worked
this-
for his father's company for these past 4 years.
Because his statement to us in December, and I may not be exactly 100% accurate, I believe his statement was he was in the entertainment field.
Prior to 2007, I did go to college for a degree in stage management, and from the time that I started with the company, from that point forward, I have not worked in the entertainment industry. I've worked
But he's
solely for the company.
never been registered, and we have no proof other than what he's saying that he was actually working with that company in security.
Thank you. So my question is, we're not going to be meeting again for another 3 months. We're going to hold this out for 3 months, or are you going to let him bring in his W-2s, tax forms, and let the office personnel take a look at it? And if he has it, we can approve it, or does this have to come back before the board?
For him when he's been here.
Well, there's been a quorum. There's never been the vote went to a tie 2-2 in December because Mr. Roberts wasn't here, and we were assuming there would be 5 here today, which would have been breaking the vote, but we're not. I don't necessarily need to see him again based on the fact that he shows verifiable proof with a 1099, a W-2, whether he was a full-time employee, an exempt, however, that he derived his income during those years from working in security because he's.
That's back to 2007 to
You just
present.
give somebody a
'Cause
QA
he's-
license that's never been registered.
I don't believe a 1099 would be sufficient for that.
That's a sub-
Well, if
1090
it had his father, if it had the security company, you know, he's just not showing us anything. And if you say no 1099, I'll go along with that.
W-2 is really what you're
We
looking
have
for.
no
W-
proof
W,
that he
W-2
worked
would show
in security.
employment. A 1099 would go to an independent contractor.
Yeah,
Well, he
W-2
could- but
shows
we've-
that he was a full-time employee under his father. If he had a 1099, that means he could run ABC company under his father.
However, the board
It's
decides
still
to
illegal-
do it, that
illegal.
it shows he was in the security field during this period from 2007 until 2014, whoever it is, 15.
This board's in the past has said that, you know, a 1099 employee could be a registered employee, and it may not be right from a tax standpoint, but as long as they were operating as an employee and
Are you in
Right.
the notion to hand somebody a QA license that's never been registered?
Why, you don't have any any indication that Mr. Bryan here has been employed in the security industry?
By any
That's the
alarm
point,
company.
He
except-
has all his letters from, I mean, he does have letters from,
Letters
from,
don't-
from customers. And the person that would really be at fault for not registering him is deceased and can't come to answer to us.
He still didn't register his son.
Mr. Bryan, can you provide, for instance, W-2s for the period of time that's in question here?
Yes, sir.
It'd be a simple matter to do that then, and then that would resolve the issue without much question, I
That
would think.
shows the bulk of, or the majority of his income was derived from that.
It will show that my entire
I'm just
income.
saying, if he was,
If it's if
Thank
it's for
you.
$1,000 for a year or something, is your point, it's or
well, I
whatever,
mean,
it's not.
we've got some tax returns here, so we know, approximately how much his income was, and if he turns in $200-300 W-2 for these years, when he's made several tens of thousands of dollars, it didn't come from that security job, that security company's arms.
Okay, so what does the board decide,
what
how
do
you
we
want me to
have here?
handle this?
We have one W-2.
I know what you want me to get. What do you,
Father in 2008, and after that,
If
you
you're
just have,
satisfied from W-2 forms, I think, I don't know if the board said
worksheets.
1099 or not. If you're satisfied that the bulk of his work was derived from that security company, then we still have the unregistered employee issue.
And we could bring, I mean, that could be brought up as a separate complaint and.
Right.
And
Well,
that
at the
would-
last meeting, I asked y'all 3 times if you wanted to set up a complaint and send it for response, and you wouldn't agree to that, because we could have already gotten that, but you didn't agree to that at the last meeting.
I don't recall that being done. I just recall there being the issue about the qualifying agent.
okay, so
at
you
the
want me to set up
December.
a complaint for unlicensed activity? Unregistered activity, excuse me. But then you'll have to satisfy the complaint before I can issue the QA license.
I don't understand how you can issue a QA license to someone that's never been registered. We don't do it for anybody else.
Well, we do it for someone from out of state. If someone from out of state came and brought some of the same documentation and said they'd worked in the industry for 5
We would
years.
accept that.
No, we have
Customer
never.
letters,
Yes,
no.
we have.
Based on customer letters? only?
Not customer letters, but you guys have actually accepted experience for companies that were working
Monitoring.
without license. No.
Not,
And a complaint had been set up, and you assessed them a penalty, and they paid it, and you accepted their experience. We have several of those.
But there was something else there besides beside customer letters.
Well, only because the complaint was established because they were working without a license, and they admitted it and paid a civil penalty, and then they had to come back and get a license, and you've accepted that experience in the past.
they ordered the registration packet, but just never sent it in.
Well, then that falls on the father, who was
And
the
that's,
qualifying
well,
agent.
now that's hearsay, actually. That's him saying that they did that.
Even if he,
Do we need to pose a motion to establish the complaint for unregistered employee activity? Okay, do we have a motion? Establish a complaint.
this is where we got to before, where I didn't think it was fair. You can't, and you said it was, but I didn't think it was fair. It's like either there was unlicensed activity and he's got the experience, or he didn't. And you said you thought it was fair to do both, though, to deny the experience and do a complaint, but
What experience?
no, I
Okay,
obviously,
thank you.
I can't, but I can go by the letters that he sent and the 1090, or the W-2 from 2008, and
I want to be an accountant, but I can get my buddies to write letters. That doesn't mean I have the experience.
I think we're getting off track here. Okay, so we're going to ask Mr. Bryan to provide to the staff your W-2s, which you say you do have.
Yes, ma'am.
All right, to prove that he worked the majority of his income in this industry. Okay, got that. Second thing is, we do have unregistered activity. Do I set up a complaint for that? Or is this all gonna fall in with the application for the qualifying agent?
The fella, I have a question about the guy that was worked for your dad for 10, 20 years. What was his name?
Tommy Saunier.
And he can't come in and testify that you worked there.
He could if the board requested that he be here. Yes, ma'am.
Registered.
If he
he's a
was,
registered
he'd been
employee.
registered, correct?
Yes, ma'am.
Why can't he
There's a
take the
letter in
QA
there.
exam and you work under him for 4 years, and then you take the QA exam, which is normally how people do it, and then it's solved, it's over, and you can keep him or release him, but you need him for those 4 years. You need
If
to
Mr.
be registered.
If Mr. Bryan has been working in the industry and can demonstrate that, there wouldn't be any need for him to do that.
I just.
That's a complication. Obviously, it would have been lots better if your father had registered you, but you can't go back and do that after the fact very well.
I'd like to ask Mr. Bryan another question. Do you have any contracts? Are you working? Is your company working?
Ma'am?
Is your company up and running? I mean, you got
Yes, ma'am.
contracts?
We
So-
did discuss that,
Yes.
and we allowed him to, we extended his,
Until tomorrow.
and we did discuss at the time, you might need to look into something else. We were afraid this, might be an issue. Do you have other options to?
The other option would be to have our technical and certified employee, Tommy, to take the QA examination. He has his NTS level 1, and which we're still in the process of trying to find his certificate. But that would be the only other option we would have.
We did discuss that at the last meeting, but that is the other issue. So what can, in that, or is there a?
You have the authority to give the company another extension while they try to resolve this, but it's gonna have to be by motion.
Well, or we could do something even shorter if it's just to verify these papers and to try to get.
Right, but if he's got another individual who's going
That
to
had
have
to
to try
take the
to
test.
qualify and take the exam, it may take a while to do that as well. I just don't want to be in a position of the board to be shutting down an alarm company that
Right.
already has contracts and already working.
I think that I would make a motion to extend well, we've already granted him an extension for Mr. Saunier to sit for the QA exam. He has many, many years' experience. Beth can find it if he's taken it and turned it in.
He
She
could-
would
he
have
could get
record
it.
No,
of it.
actually,
can-
NTS purged all their records last year before last. He might be able to get it from NTS. I don't know. They purged all their records about a year and a half ago. And if you were gonna ask for a duplicate certificate in the past, I think you had a window there, but they might still be able to verify it for him.
Have you taken the exam?
Yes, ma'am.
Oh, okay, so, I mean,
Qualifying agent.
why am I,
But-
why are we just trying to get somebody else and when have we
Because
just?
he's never been registered.
Mr. Bryan, you say you've taken the QA exam
For burglar alarms, yes, sir.
for burglar alarms. Can you tell us whether you've passed that or not?
I
mean,
have the results with me today, sir.
Did you pass it or
Yes,
not?
sir.
Okay, you passed it. So you've taken the QA exam, you've passed that.
Training, it's in the
You've
back.
got the training requirements met. The only question, as I would see it, would be that you've got the experience met in the alarm industry. And if we could validate that, it would seem to me that you've met the appropriate requirements. We've got W-2s here for 2007 and 2008. that would indicate that you were an employee of Security Electronics of Tennessee, Inc. That's 2 years, or that's the indication that I would see here. If you've got some more W-2s that would show that you were an employee of that company during, then that would, I would think, satisfy the employment requirements, and we could proceed with this matter.
I'd be happy to provide you with those.
Are you
further
planning
work.
to pursue your QA in the CCTV
I would also like to pursue a licensure in CCTV, yes, ma'am.
All he needs is the test. I've got his
Fire
training.
also?
No, ma'am.
No fire?
It would seem to me, and again, I wasn't a
I have
part
no
of this
reason to
discussion.
pull him back up here again for the inconvenience. If he can show,
You would like to see the W-2s,
proof.
though, wouldn't you?
I don't need to see them. If he's got one from that security company that comes in about the average of what those are,
Yeah, we've got two
And we've
W-2s
got-
here. One of them's for 18,000 and some change, and the other one's for close to 30,000. If he's got W-2s, we've got 2007, 2008 here. If he's got W-2s in the same general vicinity, in the meantime, can produce those to our staff, I'd be perfectly satisfied that would be demonstrable evidence that he has been in the alarm industry of appropriate periods of time. You can produce that, and I'm like you, Mr. Bryan's come all the way from the East Tennessee to appear before the board, and I guess the second time you've appeared?
Yes, sir.
Okay, and apparently through some miscommunication, you produced some documents here, but there's a question about if you could produce the appropriate W-2s to staff, I would certainly be satisfied with that. Would the rest of the board feel similarly?
I'm
'Cause
satisfied.
Those are
I mean, you
all
can-
not W-2s.
Well, we got a W-2 here on the iPad,
Yeah, I'm talking about that big stack
and
of,
we've got a W-2
Worksheet.
sitting here on top.
right,
So
for
we got two
08.
two W-2s, one for 07 and one for 08.
Right, but all this is just worksheets.
Right,
understand.
so I agree with you. So what we're simply saying is, Mr. Bryan's gonna give me proof of 3 more years of experience in the alarm business with his W-2s.
I
If
think
not, then he would have to come back before the board again. And at the next board meeting, we could give you an update on Mr. Bryan.
Sounds perfectly reasonable to me, and Mr. Bryan could fax those in or have them scanned and send them by email. The W-2s are actual formal documents that were have been filed with with any income tax. They're
I think, wouldn't it be
documents.
reasonable to request these to be, like 2010 and forward, that if he's been working in that business all this time, there would be more current W-2 forms to show that he's been working there during this period?
That'd be any sort of a problem?
I
Mr.
could
Bryan?
provide all the missing W-2s from between 2008 to present.
And the issue with him working unregistered, I think, is a separate issue. It's a
Yep.
separate violation.
I would agree.
Okay, so
That
Well,
now,
I think
that
is-
would be
it-
against the company, would it not? So he
Yes.
could still he could still proceed with his qualifying agent license.
because there's no qualifying agent for me to bring it against.
There will be, maybe.
Right now, it's just
Yeah, but that's
unlicensed
after the
activity.
fact.
That would be a fine against, it would be a complaint against the company for
I
failure to
think we'd have a
register.
hard time pressing this Mr. Bryan with that issue.
Little,
Although I suspect at this time, Mr. Bryan probably suspects that his employees are all supposed to be registered.
Absolutely, sir.
All right, Madam Chairman, let me propose a motion, and I would propose a motion that if Mr. Bryan will be able to produce satisfactory to our staff W-2s demonstrating his employment in the alarm industry from 2008 on to the present time, which he's indicated shouldn't be a problem for him, that would provide before the board sufficient evidence of his employment meeting the 5-year requirements, and that staff could administratively go ahead and if he, assuming he's met the other requirements, that they could go ahead and grant his QA license. Now, if for some reason that is not forthcoming, then we would want him back before the board to give us some reasonable, satisfactory explanation as to why that wasn't produced. But it would seem that that would not be the case. So basically, the motion is if he can produce W-2s from 2009 forward, demonstrating satisfactory employment in the alarm industry for that period of time, that staff can go ahead and grant his QA application.
Are we extending his, the fact that he doesn't have he won't, it expires tomorrow or whatever as far as.
We get this motion and then you can make a motion on that.
I'll second that motion.
We have a motion by Mr. Roberts, a second by Mr. Cockcroft to defer to staff to review all W-2 forms submitted from 2009 forward by this gentleman for consideration in his qualifying agent experience. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Aye. Motion carries.
Or granting an additional extension until he can either provide these documents or until he can get a qualifier.
I would think if I was this gentleman, I would be driving straight back to Sevierville. I'm sorry, it's cutting in and out, but I think if I were him, I wouldn't need too much of an extension to, he says he's got them and he could overnight them here.
Well, couldn't he
Still has
fax
to
them?
take
You know?
one more test.
Do whatever, however you need them, that he wouldn't need 90 days to take care of this.
I'll take the CCTV test, I don't know.
I thought he said you've
took
taken
the
whatever
burg
test,
test.
right, that for the.
I have taken the burglar alarm QA test. I still have yet to
Grant
take
him an
the
application. You can grant his
CCTV.
application in that
Add
field.
CCTV later. Let's get the company up and get it running.
I just didn't want us to
Entertain
be
a-
off by one day and have a issue there that we're.
Again, they're gonna have to have another extension to continue operating in CCTV,
Are you-
even if he get.
Do you have any CCTV operations?
We have some CCTV systems out there, yes, sir.
Going to grant the extension, what, 30 days or?
Is that sufficient for?
Would that be sufficient for you to take the exam?
I would sure do my best.
I'll make a motion.
Why
to-
don't we make it 60 days?
Okay. I'll make a motion to extend it's the qualifying agent exemption.
It's an extension to replace the QA for the company.
60 days on the qualifying agent replacement.
We have a motion, do we have a second?
Second.
And we have a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Now, let me ask for clarification. If Mr. Bryan submits his experience documentation as we've outlined here with the W-2s. He's already passed his burglar alarm examination, so he could go ahead and be granted a QA in the burg industry. If for some reason he's not successful in passing the closed circuit TV application or exam, then you would have to then stop doing closed circuit TV until such time as you got qualified to do that.
I understand.
But that
sir.
would allow your business to continue on in a reasonable fashion, even though it might not be involved in closed circuit TV. So you need to go study and pass the exam. But the other requirement sounds like it would allow you to continue on in a reasonable fashion in business.
I thank the board. Thank you for your time.
Okay, our next one is Mr. Rourke. Is that, if I pronounce that properly? Please come in and. We're here to look at, for you to approve or look at his associate's degree. It is J3.
I went ahead and included copies of some of his proof of experience also, simply because it's a little bit unusual.
Yeah, add to that, two things. I did talk with the college. They said that they put all their engineering technology degrees under the heading of applied. And also, I have some training certificates of training in electronics from the U.S. Navy to back that up if that's helpful.
Provide copies to the staff of those.
I did not provide the Navy certificates, but she has everything else.
Okay. I mean, anything that would be beneficial to your argument should be given to her.
Great copy of his little transcript, but that's.
I need some assistance in looking at these documents.
Can't get to J3.
Well, the way they're scanned, in, I can't get them to.
I've got two of them up here, and I'm not successful in operating either one.
They're just not working every time.
Help, Cindy, help.
We got it to work.
I've done everything but hit it with a hammer, and that's getting close.
So you want to go back to
How did you do that
all
so
in the
easy?
finger work. So we're on Mr.
Okay.
Work.
It works sometimes, sometimes
what
not.
What do I hit here?
Here, let's see.
Here
you
Books.
go.
Okay, books. How it's done from there? What did you do?
Use the fat part of your finger instead of the tip.
You gotta have fat fingers.
Yeah. You
Okay.
don't have them fat enough, see?
Thank
Mr. Rourke, do you have a company in Tennessee at this time, or you're wanting to open a new company at
Well,
Monteagle?
I do have a company. It's not
a
doing,
new security company.
not a security company. I want to add security licensing to the company that I have.
Okay, what kind of company do you have?
I do internet type web page design, programming, computer networking systems, things of that nature. Before, when I moved to Tennessee, I was operating a marine electronics company in which I manufactured equipment for river boats and small ships. And I'm closing that down and want to get back into the security business. I've had probably about 13 years of experience in the security industry, about 1973 through about 1986.
This was in Mississippi
That
when
was in
you had the security electronics, I believe.
Well listed.
That's the reason I included all the UL certification documentation, just so you could see that he had his own. Licensing requirement then.
I had never seen a UL invoice that small. They're a lot more now.
This is a long time ago.
So is it, I mean, we could approve on
You accept his
experience
associate.
or the
No.
degree or?
Well, again, I believe he's documented the experience, but his degree says associate in applied science. The copy didn't come out very good. I had to copy it from his diploma. It's from 1967. It's from Northwest. But since it says associate in applied science, it doesn't say electronics technology. But if you look at the courses he took, most of them were regarding electronics. We have accepted transcripts before to meet that. Due to the age, the length of time, this college doesn't seem to have any other, that's all you could get from them, correct?
Does he even need that with the experience, or is it that's replacing some of the other training?
Yes. If y'all accept this degree, he won't have to have the additional level 1 or C.
What we just passed out to was the Navy electronics training in addition to what I had.
I see sonar, but
Sonar
It's
and
kinda pushing.
basic electronics is the other certificate.
You don't do a whole lot of that sonar in the burglar alarm industry, though, do you?
yeah, I see two basic
Ultrasonic
sonar.
motion,
I
they
can't, I
used to.
can't
In
make,
a way, yes.
Yeah.
Yeah,
I can't make a
ultrasonics.
correlation between these.
It ain't sonar. All right, Madam Chairman, looking at the associate's degree here that Mr. Rourke has submitted, I would think that they would certainly meet the requirements that we would have for an associate's degree, and the coursework there, which looks like Mr. Rourke has made excellent grades. I would certainly consider adequate for work in the alarm industry. So if that is the question, and I think it is,
You would accept that
I would
degree.
accept that, and I make a motion that we accept the degree that Mr. Rourke has presented is adequate for an associate's degree to meet the necessary requirements for a qualified agent.
We have a motion from Mr. Roberts to accept Mr. Rourke's college degree in applied science electronics. Do we have a second?
Second.
And we have a second. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations.
Thank you.
Thanks.
Okay. We have one other person listed on the agenda. Do we have anybody else here? Everybody else is just for continuing ed? Break time.
Okay, we're going to adjourn, come back in an hour.
We're going to call back to order this March the 19th, 2015 meeting of the Alarm Systems Contractors Board. I think, Ms. Fess, it's the report
Yes.
time.
Yes, ma'am. Thank you very much. We're going to go to Exhibit C, which is the open complaint report. And I did not count how many we presented, how many was presented today.
I didn't really either, because
I think
sometimes
it
there's
was,
two
I think it was about
respondents.
18.
It affects the
More than
number,
that,
so
there's 20 some odd.
Okay. Well, if you just take a look at that, it says there's a total of 51. One registered employee, 4 designated qualifying agents, and 46 companies. So the report today will reflect different totals there. It also gives you a breakdown of where they are. We're still sitting there with 4 of them with 4 more charges authorized. We're working with the litigators to try to clear some of those up. That's a staff attorney right now. All right, If you have no questions about that, we'll move on to D, which is the disciplinary action report. We have our December report for the alarm board. Now, my math is always in question here, but I think that's like $1,400, excuse me, for the month of December. And then you have your January the 15th is $12,000 for disciplinary action. The February 2015 disciplinary action was $45,500. So as you can see, our attorneys have been working diligently to get these cleared up and get the penalties. Question on that, of course, that went out to you ahead of time like it normally does. Next one is the monthly report. This is another one that goes out ahead goes out in advance. Ms. Hickson, I think you're eligible for a reappointment. Have you heard anything from the governor's office? What does that mean?
She's been reappointed.
Okay, so you've been reappointed. Okay, good. I was just
All of that was sent back in January and February. Thank you.
Yes. Right, that was on the December report. Yeah, probably is. In January, that's basically all that we really have for as the alarm board is concerned. It just has the number of the complaints, how many days, and it has all the programs on there. And on the February one, you do have the fingerprint processing change. We did make a notation on that about doing the electronic printing. That is on there as well. We're going to flip right on over to Exhibit F, which is your legislative update. The first one is Senate Bill 575. This is for the alarm board, opens up Title 62, and then for Section 6232 319B, deleting the word suspend and adding the language suspend and denied. What it's done is add the word denied to under 6235 319 other suspensions. B, the board may, after notice and opportunity for a hearing, suspend or deny or revoke a certification or license issued on this part. So we're adding the word then. If it passes, which I was told this morning it has not yet, it's still sitting in committee.
Is that the intent of the bill, or is that just a caption bill?
It's a caption bill to open up 62.
End up being anything.
But we're watching that. And that's the only one we had there.
I put the bill.
You can, as you go back, this is the part that we have to fill out, the Tennessee Bill Tracking System, the General Information Book. This is where the attorney gets this bill first, and then he starts working on it, does his part there with the analysis, and then sends it over to us, and we take a look at it. We got to determine how many employees, if any, and how much it's going to cost to run the program. All that was added in on this, as you can see it. And we're saying it had 0. Okay, now we're going to come to something brand new, and is
Cody, let me, if I may interject
Sure.
something here. I had the opportunity within the last 30 days to sit in on the Tennessee Electronic Security board meeting. As I think each of you know, as by virtue of being a past president, I'm an ex officio member, and I help with their bylaws sometimes. I'm a non-voting member of the board of directors. But I thought it'd be interesting. I thought that you might like to know that there is currently a significant discussion within the association and therefore within the industry concerning the requirements for continuing education, and the industry is concerned that our requirements for renewal, continuing education is significantly lower than most of the surrounding states. So there is some interest. Now, I have no idea. They're not proposing any legislation at this point, but I felt that you'd like to know that portion of our industry at least is concerned that our requirements are significantly lower than surrounding states, and they're looking at possibly at some point in the future trying to or expressing some interest in raising the requirements, raising the bar for our industry. Again, there's not any proposed legislation. I don't think that will seem to go anywhere this legislative session, and I'm not really involved in that in any way other than just kind of an observer. But I thought you'd like to be aware of that.
They didn't tell us how many more hours, or they didn't give any particulars, or?
Well, and I'm not fully versed in all of it, but yes, I think there are more hours. They're looking at just raising the standards and raising the bar a bit. The first step I think they are going to be taking is to kind of poll the membership of this association and see if there's support to try and do something in the future on that. But we've been hearing for years, well, we require this and we require that, and it's hard to do this and it's hard to do that. And here we see the industry really saying that, well, our requirements are not up to what most of the surrounding states require, which is a real bar to reciprocity of any sort. And so I just thought you'd like to be aware of that.
I appreciate that.
Pretty sure, Ken, those are set by rule. Law just says you have the authority as a board to require it. Those are set by rule, so.
Something we could easily do then.
I'm just sharing that for information purposes.
Right, I appreciate that. Okay, well, let's look at Exhibit G, is citizenship eligibility documentation. This is something else that your companies probably already have received. If you get new applicants, these are this has been goes out with the applications. It's already on the internet, and what it's simply saying is that you have to prove you're a U.S. citizen. Your statute does not require you to be a citizen to be in the industry, but I believe this is federal regulations. Everyone must fill out the number one tells you about it. The second page is the actual form that we have to receive. And yes, it has been a block to getting people licensed because these forms are not coming in. We have to send out the document return form. We have to ask for them to do. They send the form in and say, I'm a citizen. Then they don't give you the documentation to prove that they're a citizen. So it is very labor intensive. But I did make a notation here. If you say yes, you're a citizen, if you flip back to page 3, it says a Social Security number may be verified to the Social Security Administration, according to federal law. Well, all our applications ask for Social Security numbers. All our fingerprint cards ask for Social Security numbers. All the criminal history information that I received back has Social Security numbers. So I think we're pretty much covered there. It's just getting the paperwork back into the office. But I hope all of you have already had an opportunity to see that because we have been sending it out with new applications. If you already had an application on file, of course, we didn't send it back. It's just on new applications. Excuse me. Well, if you don't have any questions on that, we'll just move to Exhibit I, which is maximum security request for a second extension. You know, I do the first extension. If they need an additional extension, we do bring it back for the board. Lost their qualifying agent, and never happened. Who is trying to qualify this one?
She is.
Mary is. Lisa Dancy, her license number is 1431, was trying to qualify the company. Mm-hmm. She's asked for a second extension.
She's only got Berg. She has to schedule the
process for herself
Yes.
to be the qualifying agent. So that's in the process then?
Yes,
Okay.
oh yes, we already have the applications in.
Okay.
So the extension would be for another 90 days.
I'd make a motion to approve her request for additional 90 days.
Second.
Okay, we have a motion and a second to grant maximum security an additional 90-day extension for fulfillment. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Now we're going to go down to the qualifying agent. We already did J1, so we're going to go straight to J2. And what we're going to look at is a criminal history, but this is for a qualifying agent. The individual came before you as a registered employee, and you approved this individual in 2008 with the same criminal. Since it is applying to be a qualifying agent, I'm required to bring it back before the board. I'll give you a few minutes to look at that. The last sheet in there is where it was presented before the board on 6/24/2008 as the registered employee. Excuse me. I probably had it.
This was originally, when he came, when the documents before, there wasn't an appearance, right? It was strictly just review of the documentation?
No, it says here, the application was presented, so he was not here in person.
Yeah.
Prior insight on, I don't remember anything from if there was an appearance, but
Madam Chairman, I make a motion we go ahead and grant this application, assuming he's met all of the other requirements.
second.
Okay, we have a motion and a second to grant Exhibit J-2 his qualifying agent. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
All right, now we're going to turn our attention to K. We have a few of them. These are our criminal record. And every one of these appear to be for registered employees. All right, this is K1.
He was
Yeah,
here.
he was here.
When y'all told him he could reapply because he had some other charges.
And there wasn't probation or anything.
He has completed all that. He had completed
probation.
all
Was
that
that the
at
issue then, or
end
was
of
that somebody else?
2014. No, the issue was that when we got his initial application, this occurred afterwards, and we didn't. Charge he told us about, and there was another one shortly after that that they disclosed while they were wanted a new background check and a new application, which meant he could go back to work
Right.
and give you an opportunity to review it. All of his probation shortly, right the first week of January.
Excuse me, you do have a letter from the company and the qualifying agent.
13 charge that came up, is that the most
Yeah, his
recent?
application came in like November of 2013.
Wasn't entirely, I mean,
He hadn't completed the probation when he was here in December either.
technically, because, I mean, I think the time had elapsed, but it wasn't, because it looks like the time had elapsed, but he hadn't paid, so I guess he was technically on probation or
Plus,
whatever.
we didn't know there was
Right.
another domestic.
But it looks like he satisfied what we were, I guess what I was looking for at the time, that the probation was
Actually
taken
got
care of and it was
several
paid,
things
and,
expunged since then too.
because we had the qualifying agent vouching for him as well, and I think he was even present at one of those.
He was
There were
here.
three, seems like there were three of them.
There were
From that company.
The manager.
Qualifying agent number required to be put on correspondence.
Both letters.
Yeah, it's at the top.
I would make a motion to approve his application.
Second.
Okay, we have a motion and a second to approve alarm employee application K1. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Go to K2. Excuse me. This is another assault case, but he has completed his probation as well in 2013.
I can be totally sympathetic.
Sometimes it works and sometimes it doesn't, but,
If you touch like in the center down
yeah.
Not able to get it to work, Scott?
I got it. So what are we on now? We're on K.
Yes, sir. We're on K2.
I'm
I got
open to,
mine, well, mine's.
open to
personal
suggestions.
We're discussing iPads, not business. We're having difficulty getting them to, back to the library files. Mine's running low on power.
I've got 3 here, and my success has been less than stellar.
This is,
I got 30%.
excuse me.
Madam Chairman, I make a motion, this is a person applying for, as registered employee. I make a
Hold
mo-
on just a sec. We didn't have anything from the employer.
They don't send it in.
We don't ask for it.
Okay,
If a company says, I'm not sending them in, we don't make the other companies do it.
okay. Go ahead, Ken.
Madam Chairman, I make a motion we grant this registered employee's application.
Second.
Okay, we have a motion and a second to grant alarm employee registration K2. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Thank you. Now we'll go to K3. This in here was simply driving on a suspended license, simple possession, which was dismissed one time. Then the simple possession was a conviction the second time, and the third time looks like it was dismissed on plea bargain.
Will the language eventually have to be changed on this application because of the?
All applications in our office is going to be changed due to the fingerprinting.
Plus the city.
Truck, I think his continues to be loaded with marijuana.
Well, yeah, I don't like there's so much stuff that's recent and all that, but it does appear as though it's in central station operator position, which at least has some supervision. I realize we grant the license, they can. Much stuff that's recent.
Providing you a copy of a drug screen. It's kind of a litigation.
You could put the individual on probation for the 2 years, hinged on it, and then run another background. This would already be issued.
Well, the way the litigation wording is on the drug screen consent order,
Yeah.
is that should a positive drug screen come up during the 1 year you're gonna monitor,
Typically, isn't that when the qualifying agent's here vouching for them or saying they'll do that, but we could.
It's a condition.
Right, they
They
could-
could say no.
They can say no and they don't get the registration.
Right.
It's a condition.
Oh, okay.
They do random
They do
drug
random
screens
drug
anyway.
screens
Yeah,
anyway.
I know we do that. Madam Chairman, I make a motion, we go ahead and grant this employee applicant, grant his application for employee registration.
With any stipulations. Okay, we have a motion to grant with employee registration with no stipulations.
Second.
We have a motion and a second. Motion by Mr. Roberts, second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, thank you. We're going to go to K4, excuse me. A little ahead of myself there. Here's just a, on your first sheet there, you do have the offenses there. The DUI conviction, felony DUI, leaving the scene, property damage, 2001 harassment, endangered child, welfare of a child, petty larceny, assault, criminal possession, petty larceny, disorderly conduct. Yeah, it is.
Requesting an appearance for this person, or a lot of this seems like might come across different in person.
Explanations?
Going on paper, I don't feel real good about it, but you know, it might come out one way or the other in person. Do y'all have a right?
Is there anything in there on the child welfare?
Again, these court records were very hard for.
Numbers, so they don't list the charge on there for you to know what you're reading.
No, you have to know what the numbers mean. Out of New York.
That's the one where he was convicted of he was only convicted of disorderly conduct.
Weapons charge in there, I think, and then that was dismissed as well. Probably where the child endangerment got involved.
I didn't see the weapons charge.
I really didn't, he said it was somebody had.
I want to have him come in and explain the charges. I'm perfectly comfortable with that.
Unless you feel like you want to deny or anything based on what we already see, you'd rather.
Having him appear is perfectly satisfactory as far as I'm concerned. Do that. Invite him to appear.
So I need to make a motion that we would.
Yes, sir.
Request for the applicant to appear
Yes,
before
sir.
the board at our next meeting. Preferably, yes.
So it would be
Second.
Okay. We have a motion by Mr. Cockcroft, a second by Mr. Roberts to have at the next meeting. All in favor, voice by saying aye.
Aye.
All opposed? Ready for K5?
All right, so listen, it depends on whether it's on it. Let me look. You want me to read what the Schedule 2s are? It's not anything clear cut, but I can tell you what it. Schedule 2s are a couple things that they could be. High potential for abuse, accepted medical use in the U.S. with severe restrictions. They lead to severe psychological or physical dependence. It includes the manufacture of it's heroin, morphine, hydromorphine, cocaine, pendazoking, barbiturates, amphetamines, methamphetamines. Greater than 2,000 grams, and it also has to do with the manufacture delivery of cocaine. Amphetamines. Those are narcotics derived from vegetable origins, which have to do with opium, poppies, cocaine, poppy straw, stimulants. To give you a better example of what it is without going into specifically what it was.
Poppy straw.
Yes, poppy straw was included. I do not know what poppy straw is. I know what a poppy is, but I do not know if the straw is part of the stem of the poppy plant or not. I can look that up.
Opium. But I'd never heard of poppy straws being a controlled substance. I was just curious. I learned something there.
Poppy straw appears to be, it says it is harvested when it's fully mature and dry. It had minimus ripe poppy seeds in it. It appears to be a dried out stem of a poppy seed.
Not a letter from him or the qualifying agent, right?
He's got each one of his little explanations.
That came with the application, with all the stuff that's typed out.
Goodness, excuse me.
Roberts, you need help with your iPad?
No, it's working at this
Oh,
point.
good.
See it bouncing off a nearby wall, you'll know there was a problem.
Please, please don't do that.
I would make a motion to deny the application K5. Or would it either be poor moral character or it's,
That's really your only ground.
you want me to restate some of that further, or we just, or I make a motion to deny K5 based on poor moral character and it's, what's the statute is 62?
Violations.
Or violation.
Excuse me, 6232, 303 A and B, and 6232, 312C. Statutes applying or concerning poor moral character. Do we have a second? Died due to a lack of a second. Do we have another?
I'm giving this some thought. Trying to analyze this in my own mind. There's a whole bunch of traffic violations here. Possession charges. Prior to 07 to 08, he went into a drug counseling that apparently was completed satisfactorily. Since then, there's been a couple more vehicle violations.
And I thought there was one more that was after that that was substance abuse, sort of a charge.
For failure to pay child support in 12.
But you can always ask the gentleman to come in like you're going to the other gentleman, if you need to.
I make a motion we ask this gentleman to appear before the board. I'm not comfortable with his record, but on the other hand, I'm not really comfortable with denying it either. I think that'd be the best thing to do.
I'll second that motion.
All right, we have a motion and a second. A motion by Mr. Roberts, second by Mr. Cockcroft to request this employee registration applicant K5 to make an appearance before the board at the next meeting. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we'll move on to case 6. Pretty simple. Other ones. Looks like a 2002 theft of property. Received judicial diversion. We shouldn't have brought this one at all.
Well, you know, the court. Oh,
Let me look.
he put
Do
that on there.
do we have a divergence of opinion here?
No, I mean, again, if it's not a conviction, it shouldn't.
This document is not, I'm familiar with these documents, but this one is not telling me what the disposition of the case was, whether it was either a guilty plea, whether or not it was a adjudication. It just has disposed.
It says judicial diversion, but I don't see that
I mean, that's what
anywhere
I,
officially.
that's what I see what the applicant said,
Well,
but
that's
I
what
don't
I mean,
have.
but I don't see that anywhere officially. I just see it
Looks
in
like there
the
are
person's words.
there's some disposition codes involved in the court inquiry. Count 1, there's a disposition code of DC, whatever that might be, and count 2, there's an NP. I'm assuming the NP is null prost, and the DC could be, some sort of diversion code. That wouldn't be illogical.
Was he required to provide us a copy of his judgment?
Yeah, this one.
Because what it looks like to me is he hasn't provided us with a copy at this point in time. If this was what we got, it looks like his application just may not be complete.
Well, this true copy is looks like a court printout that shows the disposition on it. Assuming you're looking at the same document I'm seeing, and I'm not sure what the number is. But
I am, and this document's usually created from another physical document that's actually signed by the judge and then the prosecuting attorney and the defendant, which would give us some clarity as to what that code is actually standing for.
You're talking about different charges. I don't even have those.
That's it. Yeah. That's got the third column from the right.
Well, we can always ask him to provide his document.
But what else would he provide? I mean, that's,
He doesn't have a court disposition in there.
Our copy of the expungement order.
Well, no, we wouldn't get a copy of an expungement order because those under state law are not to actually exist. So we should actually never know whether or not it's an expungement. It's
Well,
against.
he says it hadn't been expunged, so I mean, that's.
Right. I mean, that's usually the fallacy is that a lot of times people are defendants and their attorneys tell them you'll get judicial diversion, and then after after the end of the judicial diversion, the court can expunge your record, and then what they hear is it will be expunged, which is not the truth. You actually have to go back and actually get that done. And if that was his intention, it appears that he has not yet done it. So it's possible that he may have had judicial diversion, but it's still
Hasn't
pending.
been expunged,
That's
right?
correct.
But isn't this document that we're here that shows stamped a true, what is it, a true copy attested and the criminal court clerk signed it? Isn't that what the court's going to provide? I had assumed the court had provided that.
This is what you would receive from the clerk's office. They actually input this from the actual judgment document. There is a separate document, which is the judgment, which will actually show the type of offense that he was charged with, what he was actually held accountable for. It'll talk about whether or not his sentence, length of term, probation, and all of that. And then that is put into into their computer system. So what they do is they print out this from the computer system. But I know that they actually have, because I've received before, I need a copy of the actual judgment of this. Because I just don't know if we would know what the DC code is. You're right. I mean, the NP, I've seen these from Shelby County before. This is where this came from, yes. And the NP is a nolo prosequi, so the DC is, I can't even think of what a disposition code of DC would be right now. Usually
the code didn't make sense to
right,
me
it
either. But
doesn't.
So let's just.
I don't know.
Okay, I'll take this back and ask him to provide us with the actual court judgment, documentary disposition. Usually those are about like 11-17. They're a long piece. One side's going to tell you if he was arrested by who and what the circumstances were. The other side usually
Let's see if we
court.
can get that. I think
Right.
it'd be a good thing.
Right on to
Case 7, I think.
Yes, please. Actually, it looks like it was, has spent some time in the corrections. Yes, we go. The plea of guilty and judgment of the court. Charge of possession of precursors.
I don't know.
Yeah, you do. The last one we had, you're the one that told me what it meant.
Oh, okay. Well,
What are you making?
We're gonna make meth in the upstairs when we.
I don't think so.
No, I'm kidding.
We get that on tape.
No.
Probably is. We were joking. Anyway, we've had one other case like this where they had the precursors, and you had him come in. His explanation actually is in a letter from the QA.
(2001), and according to this, he hasn't had any more then.
Charges here, or is it, it's like there's, like on the application, there's multiple dates?
Right, got
Or is the
arrested in
precursors?
yeah, got arrested in '01. He was sentenced in '02, and he completed it in '03.
That's all the same.
It's all the same thing. The only other thing was reckless driving.
Madam Chairman, I make a motion that we grant this application for registration.
Second.
Okay, we have a motion and a second to grant this employee registration for I forgot the number. K7. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we'll move on to K8. This is grand theft and possession of burglary tools. Received probation, but now we're talking back in 1999 in criminal mischief, which he received probation in '97.
Completed it.
Like, the last thing we have on here is 1999.
Types of convictions are troubling, but it's been a long time ago.
That's what I was looking at, and it is a monitoring company out of Florida.
I also have the qualifying agent vouching for the still reviewing it. Ken,
I just have an extreme reluctance to allow someone in the industry that has a past record of burglary. I mean, it's just that's kind of a hot button for me. However, I think involved in a monitoring situation. He's had a clean record since then.
Talk to the person, but I do think that's kind of an undue burden in where they are. Anything where someone, I guess.
Well, see, I have a problem with that. You gonna bring a Tennessee person in, but
It's
you're
not
not gonna bring
fair,
a Florida
yes.
person in? I mean, yes, and that should not be any consideration. They want this license, they can come in, if you so choose.
I make a motion, we go ahead and grant this application for registration.
Okay, we have a motion to,
I'll second the motion.
okay, we have a motion and a second to grant employee registration applicant K8 his employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we'll go straight on to K9, which I tried to get in a little earlier. This one here in 2009 had 3 counts of purchase, possess, manufacture, and distributor sale of marijuana. He is under the First Offenders Act, though. Got 10 years probation. Only other thing I could see there was suspended driving license and disturbing the peace.
That was 2009, wasn't it?
No, that's when he pled.
Criminal action was 2009. There's nothing in your statute, do you have anything in there that says they have to have completed probation for a certain length of time?
Under the First Offender Act, isn't this a conviction till he completes the probation?
What do you mean, that we couldn't consider it as,
No.
we consider it as a misdemeanor or whatever until, or that's when the probation has been completed, or what?
Yes, well, first, if I understand, the First Offenders Act is almost like saying you're not even guilty. If he completes all this. But see, we won't know it until the probation's over until 2020.
What I see here is he has one negotiated guilty plea, started at 10-10, ends at 10-20. There was 4 counts, no prosecuted. He was required to do other substance abuse programs, so he'll be. I'm looking here and see if he had what his probation comes out to. That is. Yeah, there's no adjudication of guilt. Not all states are the same, but there's no adjudication of guilt here so long as.
Madam Chairman, I make a motion that we grant this application.
We have a motion by Mr. Roberts to grant employee application registration K-9. Do we have a second?
I have a problem. I know we don't, it's not a, that we don't have to, the probation doesn't affect it, but I have a problem with that person. I don't feel comfortable.
Well, just for clarification, is that, let me go back. I don't want to say the wrong thing and get the wrong impression.
You know, it's one of those things, the person agreed to that, and they didn't necessarily have to agree to that. They could have, that's just one of the consequences of what they did.
But he's not going to be off probation for another 5 years. You know, I guess I look at it as it was marijuana possession. We don't know how much, but presumably it was more than you would have for just personal use. He won't be off probation for years. This guy's got to earn a living somewhere. Now, it doesn't have, granted, it doesn't have to be in our industry. But I look at the court record that they've, where they have looked at it, and to me, I guess I just look at it as little more than a simple possession. Although it is more than a simple possession, I kind of view it in that light, and that was the reason I made that particular motion that we grant his registration. I guess I'm somewhat sympathetic to a guy that makes a mistake and of marijuana possession, and then he's got to support himself and the family, and you know, for 10 years probation, you know, you can't go without supporting your family for 10 years. Of course, he could go somewhere else, but still. Anyway, that's the way that was my thinking. That's the reason I made the motion.
It is, just for clarification, he is on probation. He was sentenced to 10 years, the 10 years he can serve on probation, so long as he is in conformance with the probation conditions which are listed underneath. And he pled guilty to counts 2 and 3, possession of marijuana more than 1 ounce, and it just has marijuana possession with an M, and I do not know what that means. It looks like they nolo prosequied the DUI offense and the possession of marijuana with intent, and that's usually with intent to distribute.
I think the conviction was, one count was more than 1 ounce and one was, according to the accusation sheets, I believe were dismissed.
Always asked him to come in. I think he's.
Do that?
We can do that. I mean, he can request to come in anyway, can't he? I mean, I'm not comfortable with the probation thing, and I don't know, maybe that's just a hang up I got, but it's something he agreed to. I mean, some of that, and it's just I think that's a consequence of it. I'm not comfortable with that, but he can come in and talk to us, and we may be more here. And
let's bring him in then.
Okay. So we make a motion to request. This is K9.
Oh, is it 9? Yes. Okay.
Personal appearance before the board.
Okay, we have a motion by Mr. Cockcroft to request applicant K-9 to make an appearance before the board. Do we have a second?
Second.
And we have a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
On K-10. This is criminal possession with intent to sell, which was a felony. That was in 87. 88 convicted, it was convicted in 88 with a guilty plea and got 5 years probation. And convicted of criminal sale, controlled substance, and 3rd degree. Individual will be in a Florida monitoring station as well.
1988 with 5-year probation. Madam Chairman, I make a motion that we grant this application.
We have a motion by Mr. Roberts to accept employee registration file K-10. Do we have a second?
I hadn't actually read their letters at the end yet, but there's not any issue with it being a felony even though it's old, or is we have the ability to?
If I understood the question.
A lot of these others are not felony convictions that we're looking at, correct? And one of these is a felony, is that, although they're old?
They're old.
Because there's nothing in the statute that would prohibit
prohibit
it.
you
It
from-
just gives you a list of convictions that might prohibit it.
Yeah, and she writes a letter that I had an opportunity to read. Maybe I was reading ahead. She indicates her husband was the one that was dealing with her now ex-husband. But also I'm looking at the time involved. This is 1988, and she's had a clean record since then. I just don't feel like that she would be a particular detriment or certainly a danger to the general public here in Tennessee.
All right, I'll second the motion.
We have a motion by Mr. Roberts, excuse me, a second by Mr. Cockcroft to grant employee registration file K-10 their request. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. I think we're ready for K-11.
We are. Thank you. This is a little bit 2004 simple possession, underage DWI possession, driving on suspended license. 2008 was also DUI and simple possession. Caught driving, had marijuana.
Somebody else left it in the car, though, probably.
It was an ashtray.
I haven't read
Have we
that
seen
yet,
one
but
that wasn't the case. Has anybody ever left it in the car themselves?
He admitted it was his in this case.
I hadn't read that. I thought you were talking about just in general. It does seem like most of the time.
It's mine.
I actually admitted
He
it was
owned up.
his. The first time he didn't, but the surcharge it is.
Switch, somebody admitting that it was their marijuana. Simple possession, 10 years old. I make a motion we grant this application.
Second.
Okay, we have a motion and a second to grant employee registration application K-11. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Sometimes there's just too many charges for us to list.
Did you save the best for last?
Apparently so.
I listed them, but he didn't.
A prohibited weapon, violation of probation, failure to appear, possession of drug paraphernalia convicted, had a capias out for domestic assault, violation of probation again, 5 counts, driving on suspended license, public intoxication, failure to appear, driving, and violation of probation.
And that's page 1.
Yes.
Well, this guy quit, or this person, I don't know that it's a guy.
So we don't need to take any action on it then?
All he has to do is transfer to another company. That's all he has to do.
Madam Chairman, I make a motion that we deny this application.
Second.
We have a motion and a second to deny this employee registration application K-12. All in favor, voice by saying aye.
Aye.
All opposed? Application is denied.
All right, thank you. That does complete that entire section we have there. Patient report.
And I think Tony still has some.
Yeah, we got.
Did anybody, some of the elite courses apparently I'd had for a while. The Central Station University courses, did Scott or Ken, Vivian, when I sent them to you, they bounced back. That was one of the emails that came back from my. I don't know how many of y'all remember the Security Industry Association Central Station. Offering it for a while, but the Central Station University has offering it again. They're offering one that's just a Central Station operator. It's a 40-hour in-person class, and they all have the operator instructor, which is also a 40-hour in-person class.
They were good classes.
They were really good courses.
I reviewed those way back when.
Then. That was kind of the industry standard for a long time for Central Station.
I've taken that class before, the instructor class. And, I mean, it's a good class. What, there was some question on there that you thought it wouldn't be good for some sort of.
I don't, Central Station employees don't have to have training.
But there could be a Central Station qualifying agent that would need training.
Well, again, we've got it for qualifying education and
Right.
monitoring and continuing education.
I mean, I would think it would be good for any training, even if you've got a burglar alarm or fire alarm installation person, for them to understand the Central Station aspect is good. So,
If some company wanted to sell one of their employees,
yes,
we could.
I'd be comfortable with.
I just put a question mark on there because I really didn't think it was applicable.
There definitely would be Central Station qualifying agents that would need that or could use that for a.
You want to make a motion then that we approve both of these two courses?
Do we want to go through all of them? All of them, because we also had the other.
We have several elite classes there, 1 hour.
They all looked.
Right, what we're saying is you
Fine.
want to go through the entire list and vote at the end?
That's what we did. Had been doing.
Sometimes we do, but then sometimes there'll be one that they want to modify a little bit, so.
I found no problem with the courses that were sent to me for review.
I didn't either. They all looked fine. I looked through
Very
all of
good.
them.
Make that motion.
I make a motion that we approve the courses that were submitted for review as they were submitted.
Second.
Motion by Mr. Roberts, a second by Mr. Cockcroft to accept the education review report as presented with the courses. All in favor voice by saying aye.
Aye.
All opposed? The motion carries. You're
Well, that
welcome.
went quick.
Well, that was the
Hey.
easiest part of the whole
Why
day.
didn't we do that earlier?
Really?
We got to review that ahead of time.
Yeah.
I think we're now down to unfinished business, and we do have some.
Correct.
We need to go back to Exhibit K6. This is the one where we were going to request the more disposition because of the DC that was on the criminal record. We didn't know what the DC was standing for the theft of property.
Mr. Roberts, I have in front of me a document from the internet from the Shelby County's website that has these things, and we now know what DC means. It means dismissed with costs. And that was on that count, and on the disposition code of the run previous, that was also dismissed. So I don't see anything in these records that actually show. The NP is, in fact, a nolle prosequi, without cost.
Okay, well, with that information, then I would think it appropriate to approve that application. As I recall, we were going to invite that person to appear, and but I think given that information, it would be fully appropriate to grant that application. So I make a motion to that effect.
Second.
Okay, we have a motion and a second to grant K-6 employee registration application. All in favor voice by saying aye.
Aye.
All opposed? The motion carries.
Madam Chair, I said that I would come back this afternoon with a recommended regulatory flexibility addendum and economic impact statement for those proposed rules that I sent to you earlier. So I would like to pass these up for y'all's consideration and voting. And earlier, I apologize, but I failed to request you all to do to give me authorization to file those rules by roll call vote. I need that, and you all have 3 here, so that's fine. But I wanted to make sure that our procedure was correct because it is required on the filing to show that.
I'd forgotten that does need to be a roll call.
I think what we're going to do, you ready for me to do the roll call on the rules? You want to wait till the end? Let's do everything, and then we'll do the roll call at the end.
The only thing we need is a motion to approve the attorney to file these as presented. Because of our agreement with the language contained, we don't need to make any changes to it, correct?
Motion to approve or to accept this document, the regulatory flexibility addendum. Is that correct? Is that what
Yes, and what this does is that this addendum is required so that when agencies propose rules and look at rules, that they're determining whether or not the rules could be flexible to small businesses and the impact on them. And this is this rule about the fingerprinting really says, well, it's actually taking out some flexibility for the applicant, saying, oh, just provide electronic fingerprints. But the idea is that the electronic fingerprints is actually going to save them money, and it's going to more streamline the procedure. So the flexibility here is not necessarily better. So it's an attempt to make an explanation of that is the general gist of those. And then the economic impact statement indicates that basically the economic impacts should actually be de minimis for most persons. Those actually submitting applications would have a lesser cost. And I think I have in there $48 to $36, and I think that is probably more. Okay, so the 48 should be 60, and I can change that. That's actually not a. And that one is 36. So the actual costs were 60 and 38, but and I'll make those changes in there. But the idea is that this process is actually going to make it cheaper for the applicants, and we'll put the exact dollars in there. And it doesn't have to be exact. It's really just a ballpark guess as to what it's going to be. But they really want to know if we looked and see, will this actually cost somebody more money with the information that we have now? And so that's
actually, it's not as convenient. Our particular case is we were able to do fingerprint cards locally, and now we have to drive to a nearby town in order to get our employees fingerprinted. So the cost is decreased, but the indirect cost to employees to travel to a nearby, in fact, I think they have to go to Tullahoma now in order to get their fingerprints. It's yep. Look, if you want this job, you go down and get yeah.
But we could put that in there. I did not know that. So we can.
It's not a barrier, and on the surface it would appear to save money, but in reality that's not particularly the case. And that's just as a point of information. That's not an obstacle. I think we need to continue on with the rule as it's proposed. But I just thought I would share that bit of information that even though
it's not a charge to the business, it's a charge to the individual, isn't it?
Yes.
If you're going to hire them, a lot of companies do pay for that.
We don't pay for the employee to drive to Tullahoma.
But the employee has to spend their gas money to get there or whatever.
We've been saying it was less expensive and more convenient, but in reality, that's not always the case.
Well, I could recommend then that we, under number 2 for the economic impact statement, projected reporting, record keeping, and other administrative costs, that we could put that note in there, that it's noted that it could take more time and effort for people to actually go
for an employee
to go to an actual designated contracted site, which has time and cost associated with it. So I can make that recommendation to put that.
It might be appropriate to note that again. I concur fully with what's being done here. I think I made the motion earlier. It's the right thing to do, but like I say, just for information purposes, it's not necessarily more convenient. It does save the time you have to use to get the ink off your fingers. Now that's nice. And those vinyl gloves I used, they didn't work at all.
I sent out notification that when I'm going to accept hard cards, so I had a guard company take fingerprints and send them to me on notebook paper. instead of the cards. I had to make a telephone call on that too.
Bit of levity
Here you
in
go.
the.
Just a little,
Right.
people read things differently.
All right, do we need a motion at this point?
I think you're gonna make an addition to that about a minor,
Yes, your motion would be,
except as presented with the addition of, one clause about the potential for employees to have to travel to a
minor inconvenience.
site collecting electronic fingerprints would basically cover it, correct?
yes, and I'll add that in there.
And they wouldn't even really have to do that if they wanted to send them to L1, I believe it was called. They wouldn't have to drive those extra miles, so.
But we don't have the assertion that that would be any more convenient
True.
to go through, jump through those hoops, so.
All right.
Again, that's what we're doing. Anyway,
I think,
so.
Mr. Cockcroft, did you start the motion to
Good.
accept as presented? No?
Well, would you like to?
You can state all that better, whatever.
I would have swore I heard it come from the left ear, but maybe it's the right brain. Go ahead.
Madam Chairman, I make a motion that we adopt the rule change here, that we've made some notes as to the economic impact statement that council will be adding, but that we adopt the rule change and that we authorize our council to present this to the Secretary of State for an expedited approval.
Second.
Okay, we have a motion and a second. Motion by Mr. Roberts, a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
Aye. All opposed?
We need a roll call, don't we?
Oh.
Isn't that what we
for
needed
both
a
matters.
roll call on?
Yes, yes.
Oh, is this the one we need the roll call on? Excuse me.
We need a roll call on the adopting the new rule and on this, yes.
Okay. Back out the,
Yeah, the motion included both the adoption and the,
Ms. Fest, would
And
you
the-
please call the roll on the motion and as seconded by Mr. Cockcroft?
Ken Roberts,
yes?
Vivian Hickson,
Yes.
Scott Cockcroft,
Yes.
motion carries.
Thank you. Okay. Anybody in the audience got anything? All minds clear? Meeting's adjourned. See you in June.